One side. I need to make one mention before your judgment regarding observations which were made before in the context of then Senior Counsel Naganand. During the course of his submission, he referred to certain organizations and complaints being filed by teachers regarding certain threats which were issued. But we have registered one first information report and one an information we received which was not converted into a complaint. But I have a sealed cover progress investigation progress before it. And I'll just place it. What's its permit?
After at the end of the day.
Yes. Yes.
Because
very.
We are trying to finish up with
very.
Yes.
Lord, may I be permitted to mention, Lord, a petition, which is, Lord, we although filed a civil, Lord, an IA earlier seeking to intervene in the earlier petition.
Yes.
But now thereafter, Lord, we decided to file a petition because, Lord, there was some reservation expressed by the court for hearing the interveners. Now, that writ petition is 4338 of 2022. Lord, that petition which we have filed, Lord, seeing what is happening, Lord, after March of filing of the petition.
It is here.
Yeah.
It is here. We will hear you.
Yes, ma'am.
Let your turn come.
Yes.
Yes. Start with the arguments.
May it please, Lord, so I beg to.
Yes, you are for respondent number 8.
Respondent number 8, my lords, in 3146, my lords. I am obliged to my lords for the indulgence, my lords, for a few minutes to make some submissions.
Only request is that be brief as much as possible.
Absolutely, my lords, absolutely.
We are running out of time.
I fully understand, my lords. I fully understand. I am obliged to my lords.
We cannot accommodate every day.
I follow, my lords. I follow. Only to supplement, my lords. In fact, I will not even take the 15 minutes which was sought from my lords. Only a few minutes I will take, my lords.
Yes.
There are two perspectives I wanted to place for my lords' kind consideration, my lords, in the entire matter. Wide-ranging submissions have been made from either side, my lords.
Yes.
The regulation which is now sought to be challenged, my lords, in my respectful submission, would have to be considered from the point of view of, my lords, the objective it seeks to, my lords, achieve. The objective in my respectful submission, my lords, is bringing about, my lords, uniformity in, my lords, the treatment of students in an educational institution. Now that, my lords, is an objective which is in furtherance of, my lords, the act itself, the Education Act itself, and, my lords, to ensure non-discriminatory, my lords, treatment of students in an educational institution. We are dealing with, my lords, activity which is essentially, my lords, in a secular space in that sense. The moment, my lords, a student comes to an educational institution and partakes in, my lords, the imparting of education, secular education, any, my lords, regulation or stipulation brought in, my lords, to bring about non-discriminatory treatment of students would have to be viewed in the light of that objective and cannot be sought to be questioned, my lords, on the premise of Article 25. That's my submission for my lords' kind consideration, my lords. Of course, the concept of, my lords, a uniform itself in an educational institution is for the laudable purpose, my lords, of ensuring that whatever be, my lords, the background of the students, whatever the background they come from, whether they are penurious, whether they are from an affluent background, what is their caste, what is their creed, what is their color, what their religion is all sought to be completely obliterated. In that view of the matter, my lords, my respectful submission is the regulation that is brought in would have to be tested on the anvil of the objective of non-discriminatory treatment of students pursuing, my lords, education, secular education in a secular space. This is one perspective I wanted to place for my lords. Can consider, my lords.
Yes.
The second aspect, my lords, that I wanted to highlight is, my lords, the nature of jurisdiction, my lords, that is exercised by constitutional courts in such matters. My lords, notice that the grievance of the petitioners is premised, my lords, mainly on the ground that, my lords, the wearing of the attire in question is part of essential religious practice and therefore protected by Article 25. Now, my lords, the nature of jurisdiction that is exercised by a constitutional court when such a claim is made is not really part of, my lords, any ecclesiastical jurisdiction. That's an important facet, my lords, which will have to be borne in mind in my respectful submission. It is really as a matter of constitutional necessity that the courts get into it. And therefore, there are, my lords, limitations to what kind of determination can be done. Now, this aspect, my lords, has been taken note of by the Honorable Supreme Court in one decision. That decision, my lords, is Adi Saiva Shivacharya versus State of Tamil Nadu. That's reported, my lords, in 2016. Volume 2 Supreme Court cases, page 725, my lords. My colleagues, my lords, who are physically present in court, I understand, would be carrying a copy and perhaps provided for my lords ease of reference, my lords. Just one or two portions there, very, very small portions.
You write around the statement notice. You don't have the ready copy. You are trying to obtain. Unless I obtain that.
May I give, my lords, the para reference and read them, my lords, so that the judgment can be circulated to my lords, my lords?
We will consider it.
Yes.
You proceed further.
Yes, my lords.
Give the paragraph.
Yes,
Then
paragraph number 38, my lords.
38.
Yes, I'll just read one or two portions in that, and then from 43, I'm done with that reference, my lords. Paragraph 38. May I place that, my lords?
What has been said in that? What is the ratio laid down?
The principle that is noted by the court is this, my lords, that the ecclesiastical jurisprudence in India is really not something which is conferred on courts, but because there is a claim made, my lords, under Article 25, the constitutional courts, as a matter of necessity, are going into such questions. And it's not easy, it's not an easy question to determine. May I just place one or two sentences from that, my lords? The para 38, the ecclesiastical jurisprudence in India, sans any specific ecclesiastical jurisdiction, revolves around the exposition of the constitutional guarantees under Article 25 and 26 as made from time to time. The development of this branch of jurisprudence primarily arises out of claimed rights of religious groups and denominations to complete autonomy and the prerogative of exclusive determination of essential religious practices and principles on the bedrock of constitutional guarantees under Article 25 and 26 of the Constitution and the judicial understanding of the interplay between Article 25(2)(b) and 26(b) of the Constitution in the context of such claims. Then, my lords, they go into Shirur case, etc., etc. Then, my lords, paragraph 43. Paragraph 43, my lords, at page 753, placetum B, my lords.
Yes.
The rights guaranteed by Article 25 and 26, therefore, are circumscribed and are to be enjoyed within constitutionally permissible parameters. Often, occasions will arise when it may become necessary to determine whether a belief or a practice claimed and asserted is a fundamental part of the religious practice of a group or denomination, making such a claim before embarking upon the required adjudication. A decision on such claims becomes the duty of the constitutional court. Now, the next part, it is neither an easy nor an enviable task that the courts are called upon to perform. Performance of such tasks is not enjoined in the court by virtue of any ecclesiastical jurisdiction conferred on it, but in view of its role as the constitutional arbiter. That's important.
This is what we are doing.
No, that's right. I'm saying absolutely, my lords. I'm only saying my lords are doing it as a matter of constitutional necessity in the position of being a constitutional arbiter. And when there are, my lords, disputes being raised on whether something constitutes essential practice or not, then, my lords, the question becomes all the more, my lords, intricate and difficult to determine. I'm only placing in perspective, my lords, the stated claim of the petitioners based on certain sources and judicial pronouncements. And I recall, my lords, the Honorable Advocate General, my lords, had placed some portions from versions of the Quran, which would be suggestive of, my lords, some kind of contestation of the position as claimed by the petitioners. In that scenario, my lords, my submission is, please look at the claim of the petitioners from the point of view of the objective that is sought to be achieved, which was my first submission. The regulation is dealing with an activity of the petitioners, which is not, my lords, religious or performance of anything religious, but connected with, my lords, their secular activity of pursuing education. Therefore, that I want to, my lords, juxtapose and place in perspective in the context of how, my lords, this area of determination by the Constitutional Court, my lords, is bristling with, my lords, various ponderables. That's the second point I wanted to highlight, my lords, because that's the main premise on which, my lords, the entire grievance of the petitioner has been projected. That I therefore wanted to place, my lords, for my lords' kind consideration. A third aspect I wanted to highlight was this, my lords. My lords, recall the scheme of the Act, my lords, where Section 7 makes provision for curricula to be prescribed. There is, of course, the argument by the petitioner saying that, my lords, dress code can never be part of, my lords, curriculum. The Learned Advocate General has referred to, my lords, various provisions in terms of the scheme of the Act and the rules, my lords, to take reference to the provision for a uniform. There is one other angle, my lords, which perhaps my lords may consider looking at, my lords, which is, my lords, Section 7, subsection 2, my lords. Kindly have a look at that. Please 7.2, my lords.
What is that?
That says, may I read that, my lords?
Yes.
The curricula under subsection 1
Yes.
may also include schemes. Please look at the expression, my lords. The expression used is schemes in respect of various aspects enlisted as A, B, C, and D, and so forth. Please see G. E, of course, is promotion of national integration. E, my lords, have seen as promotion of national integration. Now, G, my lords, inculcation of the sense of the following duties of citizens enshrined in the Constitution, namely, please have a look at 5, my lords, subclause 5. To promote harmony and the spirit of common brotherhood amongst all the people of India, transcending religious, linguistic, and regional or sectional diversities, to renounce practices derogatory to dignity of women, etc. Now, my lords, as I said, the purpose of prescription of a uniform or a dress code is really to, my lords, bring about equalization and equality in a common platform. Now, the Act, therefore, consciously, my lords, contains a provision of this nature, where it says schemes could be made. And that is how, my lords, the regulation in question would also have to be considered in my respectful submission. Then one last point, my lords, again for my lords' kind consideration and perspective, my lords. There was a reliance, my lords, on Article 19(1)(a), freedom of speech and expression. Now, it is, my lords, well recognized that there could be speech and non-speech components, my lords, to the freedom of speech and expression. Now, this part of, my lords, regulation of this activity would really be covered by non-speech regulation or non-speech component of, my lords, freedom of speech and expression. Now, there is a principle which is evolved, my lords, in jurisdictions abroad and recognized by Indian courts, that, my lords, there could be regulation of non-speech activity if it is, my lords, to achieve a larger common good. That principle, my lords, which is enunciated, my lords, in United States versus O'Brien, is noted by the Honorable Supreme Court of India, my lords, in one of the judgments. I'll just give that citation, my lords. Bennett Coleman versus Union of India. I understand, my lords, now both the judgments have also been brought to court, my lords, and they'll be circulated to my lords. Bennett Coleman, my lords, is 1972, 2 SEC 780. That judgment, my lords, would recall is in the context of, my lords, newsprint policy, which was challenged, saying that, my lords, it affects the freedom of speech and expression. Ultimately, my lords, by majority, my lords, the policy itself was struck down. But the principle, my lords, is noted, which my lords will find at page 814, my lords, para 48.
Page?
Page, my lords, 814, my lords.
814.
Paragraph?
48, my lords. May I just place that? May I place that?
Yes.
The other American decision on which the additional Solicitor General relied on is US versus O'Brien. In O'Brien's case, the court held that one who had burned one's selective service registration certificate did so in violation of a federal statute, making the known destruction or mutilation of such a certificate a criminal offense. It was contended in O'Brien's case that whenever the person engaging in the conduct of burning the certificate intends thereby to express an idea, the idea of both speech and non-speech elements were combined to the same course of conduct. It was held that there was a sufficiently important governmental interest in regulating the non-speech element. The court noticed there that such incidental limitation on First Amendment freedom was justified because an important and substantial governmental interest was involved. The governmental interest was found to be unrelated to the suppression of free expression, and that the incidental restriction on any First Amendment freedoms involved was no greater than absolutely essential in the furtherance of the governmental interest. Then, of course, my lords, 49, they say how they lay down the principle, but on that case, my lords, the newsprint policy was found to be violative of Article 19(1)(a). That really doesn't make a difference. I'm on the principle, my lords. In fact, this approach, my lords, is adopted in some later decisions to justify prescription of a discord in educational institutions in the US itself. And why this becomes relevant, my lords, is we substantially, my lords, adopt that jurisprudence for freedom of speech and expression in the context of our constitutional scheme. There are 1 or 2 judgments, my lords, from that jurisdiction on that point. I'll have them circulated, my lords. I will not trouble my lords just now with all that. We'll have it circulated, my lords. But this is the principle that I wanted to place before my lords. Then one last aspect, my lords.
Yes.
The regulation in question, my lords, will have to be also understood in the light of the fact that, my lords, it is not intended to achieve the goal of interference with religious rights. That's important, my lords.
Which regulation you are talking about?
The concerned GO, my lords, the impugned GO.
Yes.
Now, the object or, my lords, the goal of that GO is not interference, my lords, with religious freedom per se. It only is to regulate, my lords, activity, as I said, my lords, as part of pursuing of education, as part of secular activity. That's the last aspect which I wanted to highlight, my lords. I therefore respectfully submit, my lords, that in the light of these factors, this grievance as projected by the petitioners, my lords, would not be really justified, my lords, in my respectful submission. I'm really obliged, my lords, for a patient hearing, and my apologies for taking that extra time from my lords.
Thank you. Thank you.
Obliged.
Yes.
May it please, my lord. My lord, can I finish my rejoinder, my lord, because new petitions, my lord. My lord, we may have nothing to do with the lordships, may hear them. Lords, lot of submissions have been made, my lord. So I need to, my lord, get a little bit of time, my lord, to respond.
How much time you will take in rejoinder?
Lords, I will try to finish it today, my lord.
Today means still.
Lords, in an hour, maximum hour's time, my lord. I'll finish within an hour, my lord. I will not take more than an hour.
Lord, may I say this, my lord? Your lordship may hear us.
Hearing me, new petitions.
Because this may be concerning Mr. Kamath himself personally.
Mr. Kamath, it would be better if we hear all the petitioners first before we start.
Up to your lordship, we are in your lordship's hands. Whatever lordship.
You will have the arguments of all the petitioners. Then only you give the rejoinder. It would be better.
Very well. Whatever is appropriate for your lordship, I will go back.
We will start with the fresh cases.
Yes.
Whatever are there on board. Is the list. Call.
1.1. Ramatullah Kotwal.
Kindly, my lords, appearing for the petition in this review petition. My lords, I've filed the copy of the order with the memo. It may kindly be taken up. I bring your kind attention to para number 5 of the order, my lords.
The review petition.
Yes.
Ask you the fresh petition. We will take up this afterwards. We'll take up this review afterwards. First, call the first petition.
Number 1.6. Aditya Chatterjee.
May it please, my lords, I'm led by Senior Counsel Ms. Kirti Singh, if she may be permitted to.
May it please your lordships.
Yes.
I'm not going to repeat any of the arguments on Article 25, your lordship, as it has already been extensively addressed. So my arguments are going to be.
You are for All India.
I am for the All India Democratic Women's Association, lordship.
Yes.
So one intervention, lordship's permit, before my learned friend starts.
Yes.
I just have only one request to be made. This I am instructed to submit before your lordship's permit. The petition does not disclose as to first petitioner which claims to be an association is registered under which provisions of that. That clarification may be given so that it will help lordships.
Are you a registered body?
We are not a registered body, Your Lordships, but we have fought. We are a mass organization of women, and we are therefore being represented by our Vice President, Vimla, K. Vimla, and we have in fact fought several PILs on because of this, which the list whereof we have given. Even currently in the Delhi High Court, we are arguing 2 petitions, one on marital rape and another one. So this undertaking we had given, and we have given the list, Your Lordship.
Is there any resolution in
And
your
we are a
favor?
mass organization of a crore of women, Your Lordship, and the Karnataka chapter itself has 1 lakh women. So we are not of all creeds and comprising of Hindus, Muslims, Christians, and particularly marginalized women, the SC, ST women.
All right, before we come to the maintainability of this PIL, on behalf of the petitioner, first we would like to know as to, is there any authorization in favor of your Vice President, Srimati Vimla KS, who represents the petitioner number 1?
If I may assist, my lord, that's at page 86 of the paper book, my lord.
Page 86.
Please, my lord.
This is the Wakalat. This is the Wakalat.
The very next page after the Wakalat, annexed with the Wakalat, is the resolution dated 15th of February 2022.
The members have to disclose. Once a committee would generally chief has seen the members of the committee who attended, who was absent. That's how the resolution should be. Otherwise, we will not know its credentials at all.
What is this resolution? It is signed by the one Devi. Which committee? What committee? What is the constitution of the committee which has met and took the decision?
Your Lordship, it's the central committee of the organization, which
it doesn't talk about it. Doesn't say what is the constitution of this committee.
Lordship, I in fact don't have a copy of
resolution.
With my lord's permission, if I may point out, my lord, the letterhead is of the All India Democratic Women's Association. At the bottom, my lords will see is the signature of the president, Miss Devi, along with the rubber stamp that reads All India Democratic Women's Association, Karnataka State Committee, and the address, my lord. This is the extract of the resolution.
It cannot be treated to be a resolution, Mr. Very sorry to say that.
With my lord's permission, I'll only request if the entire minutes and along with the constitution of the organization has to be placed, I will undertake to place that. My most humble request is
even the constitution of the committee which has discussed the issue which you say the committee discussed the issue of dress code. Which committee?
The Karnataka State Committee, my lord, which is the rubber stamp that has been affixed at the bottom of the letterhead.
What is the constitution of this committee?
Place it. Place.
I will place it, my lord. My instructions are it consists of 34 women elected from across the districts of the state of Karnataka.
Not maintain a petition on behalf of an organization like this. You have to annex the resolution, the proceedings, and the decision taken in that meeting, disclosing the constitution of that body which is taking the decision, and thereafter, where is the authorization?
My lord, the president is authorized, and the authorization is in the last para. Hence, the meeting unanimously resolved that Mrs. K.S. Vimla, Karnataka State Vice President, to sign all pleadings, affidavits, memos for the purpose of these proceedings. My request is, my lord, if for all the additional documents, including the constitution of the organization and the entire minutes of that meeting, I will place it on record.
Resolution is
My-
not signed by only president. It has to be signed by everyone, whosoever has attended the meeting.
There's an extract of that, my lord. I'll requisition the entire minutes book and I'll place it. My only request is if my learned senior could address the court, I will ensure that whatever additional documents are required with an affidavit are placed on record.
Yes. All right, now we come to the maintainability part of it. How you agree?
Your Lordship will see that the second petitioner
You are
is,
espousing the cause of women in general.
Your Lordship, we for the last many years, since 1981, have been taking up issues
The agreed
concerning
persons are
women.
before the court. Madam, the agreed persons are before the court. You don't have to espouse the cause of anyone who has not come before the court. When they are there before the court, what is the need of you to come and espouse the cause?
No, because we have other women who have different grounds on which to come before the court. The entire picture has not been put in front of the court, including the legal picture. I'm not here to discuss the factual matrix. I'm here to.
Please go and assist the persons who are said to be aggrieved and have approached the court.
Your Lordship, the second petitioner is
before the court. You
Your
cannot.
Lordship, in the Supreme Court we have intervened. We have filed petitions.
We are
In
very
the
little
high
people
courts we have filed
and
petitions
small
across
people,
the
and
country.
we know about our court. In this manner, we cannot permit you to espouse the cause of the persons who are already before the court.
No, it's not only the cause of the persons who are already before the court, it is also the cause of many Muslim women who are part of our organization.
Only to the students, and those students who feel aggrieved, they
Yes.
are before the court. It is not general for the all people at large.
No,
This
no, it
government
is only, but
only
every
to the
issue.
people.
I appreciate what your Lordship is saying, but it is every issue that affects, for instance, the petitioner number 2 is a person who has 3 children who are school-going children, and she is aggrieved by this. So therefore, it's not only the petitioner number 1 who has members who are deeply affected by this order, by the impugned order. It is also
Interest and public interest cannot be mixed.
I will just put across 2-3 arguments to your Lordship. Your Lordship may consider it. I realize that your Lordship has very little time. I will not repeat the arguments on the ground
Satisfy
of
us on the maintainability of your petition.
your Lordships. I cannot say except that we are a genuine party. Your Lordship can see that because of the undertaking that we have filed, of the number of petitions that we have filed, we filed both at the level of the lower courts, at the High Court and on the Supreme Court. Your Lordship will see we take victims of violence to the police. We go and argue their case and help them argue their case in district courts. We come to the high courts when an issue is involved. So your Lordship will see my entire, if your Lordship will just go through pages, if your Lordship will see at page 4 of the petition, that's where your Lordship will see paragraph 5 on page 7 of the petition, where I have detailed to some extent, obviously not a very great extent, of what we have been doing, but we are a well-recognized social
We are not
work.
on your, we are not on your credentials. We appreciate your concern, but the thing is, your petition would not be maintainable when the aggrieved persons are already before the court.
Your Lordship will see that there are people who are members of our organization who are also aggrieved. The woman who is in front of petitioner number 2, who is in front of you, has also 3 children, and that is why she has come to this High Court. If we were not concerned with the issue, if we are not agreed with the issue, yes.
Sorry, we are not satisfied regarding the maintainability of the writ petition. We will pass the order.
Your Lordship will see that I just wanted to bring up the issue of freedom of expression and the limitations that could be placed on it, and say that this order is directly affecting our right to education and access to education.
Agreed persons are represented by very, very competent lawyers. Very, very competent lawyers are there appearing for the agreed persons.
But this
So
is,
if you want to add anything more to that, please assist them.
Your Lordship will
cannot
see that. Lordship
open
will see
this
that we
Pandora
wanted
box.
to argue on the ground of equality, Article 14 and 15, and then say that the onus of to prove that the impugned order can satisfy 19.2 has to be on the state, which the state hasn't discharged. So, will your Lordship not hear me?
Thank you. Next.
Lordship, nobody has brought these arguments before your Lordships, and that's why I've come. Nobody has spoken of the different principles, and that shows that we are an organization which will put the women's perspective in front of your Lordships, besides which the petitioner number 2 has a right to address your Lordships.
No, Apex Court has said personal interest and public interest cannot be an admixture in PIL jurisdiction. Therefore, even that argument does not avail to you.
No.
That's what the Apex Court has said. If you say no, we are helpless, except dismissing the petition. Yes.
Thank you. Thank you. We'll hear you in some other matter.
Your Lordship, this was a matter which was of national importance, because there is no reason. The girls are wearing their uniform. There is no reason whatsoever why the hijab, which is just a headscarf, should not have been permitted. In the schools, we are not against uniform, but we have to see what is the least restrictive way of saying of not interfering with the right to education that these girls have. And it has been pronounced in the judgments of this court that the right is a fundamental right concomitant with the right to life. I just wanted to bring in the whole spectrum of rights which these girls are entitled to: the right to choice, the right to freedom of expression, which can only be curbed by
all they have been argued for 1.5 days.
Reasonable. Sorry?
All they have been argued with 1.5 days with foreign judgments, not only native judgments.
No, the freedom of expression, but there has no explanation been put why Article 19.2 will not apply to it. Why strict scrutiny will not be paid to this. The court is under an obligation to strictly scrutinize the legislation. And why the wearing of scarf is not causing any public order if there is a reaction by members of a certain party.
Number 1.7, Mr. S. Balakrishnan.
Is 1.9, Mela?
1.7.
3942 of 2022.
Balakrishnan.
3942 of 2022. Mr. S. Balakrishnan. You'll be fine. What are the office objections? In the report. That is not it. Okay. Wasn't, that has not been annexed. Copy of wasn't. This is again not mentioned. As per rule 41.
You have to strictly comply.
Call it again.
1.7, Shreyas Balakrishnan.
In spite of repeated call, no one responds. For the petitioner to press this writ petition, as per office report, the following objections have been reported. This public interest litigation has been filed without complying Rule 14 in bracket 1, High Court of Karnataka Practice and Procedure for PIL Rules 2018. The writ petition in the given facts and circumstances not maintainable is accordingly dismissed, as well as for non-prosecution.
1.8, Mohammed Tahir.
Waiting for the petitioner, Lordship. In 1.8 and 1.10, Lordship, I seek leave from this honorable court to withdraw both the petition, Lordship. 1.8 and 1.10, Lordship.
1.8, write down. Mr. Mohammed Tahir,
Waiting for the petitioner, Lordship.
counsel for the petitioner. The writ petition has been filed seeking following relief. Mr. Mohammed Tahir, counsel for the petitioner, makes a statement at the bar that he does not want to press this writ petition, may be dismissed as not pressed. The writ petition is accordingly dismissed as not pressed. The same order may be passed in writ petition number
1.10.
1.10.
Yes, Lordship.
Yes.
0.9, Munir Ahmed.
Yes, I'm appearing, my lord, in this matter. I rectified earlier the errors. I was given a liberty by this honorable court. I've explained the cause of action in para 12 of this petition. It was your lordship's magnanimity that time a liberty was given to me. I have explained more, my lord, perfectly the cause of action in para 12.
Paragraph.
Yes, the petitioners all along since beginning of their academic stint were usually wearing the hijab by mode of putting the head scarf and no time hided the face and their hands as has been uncovered only after 5th, that is after the issuance of the impugned government order. Produced herewith the school authorities compelled and insist the petitioners to remove hijab, head scarf, in default whereof the entry was prevented under the garb of impugned government order also. Therefore, it is respectfully submitted that the cause of action has accrued to the petitioner on 7th and on 9th, when on the basis of impugned government order dated so, they were denied entry to their respective institution by respondent number 6 and 7 in connivance with unscrupulous elements while wearing hijab by stating that there is a government order which was wearing a hijab is in the institution, thus the petitioners cannot enter the institution premises while wearing hijab and a cause of action occurring. This my lord has done. Now your lordship, with my lord's permission, my lord, I am a little bit.
All right, who are the petitioners?
Yes, I have said it in para. They are students, my lord. Yes, I have said it in para 4.
No, this is a government college.
Yes.
New
Yes.
Horizon College
It's a
and
government.
Chaitanya Techno School.
New Horizon College is not a private, it's a private institution, not a government institution.
So,
Yeah.
sir,
Yes, is a regular studying there. There we have been also denied. That's why I am before your lordship. It is not because I am on a FedEx. They said that you cannot enter. You cannot enter. That is the problem. Yes. My lord, I can assist you all. I have read the Arabic Quran also. I would assist your lordship. Yes.
You have said that you are studying in New Horizon College.
Yes.
Both are private schools.
Whether
Yes.
this is a government college?
Private.
There we have stopped, my lord, at the entry gate. That's why I'm submitting. On 7th and 9th, they did not permit us. And they said,
You
you
are not
remove the hijab and then come.
You are not answering my honorable chief's question.
Yes,
Please answer.
please.
Whether they are government colleges where the petitioners are studying. These both
But-
the institutions, whether they are government aided or government colleges.
These are government aided, my lord, but we are studying there and this
I
is
know
a
in
fact. my lord.
that school, I have studied in that school. I have studied.
Yes.
It's in Karnataka.
We
I
were-
know it very well.
We were
Yeah,
prevented
but-
there, my lord. That is why I am
Private
before you.
institution.
Otherwise, unnecessary, we will not give trouble to your lordship.
New Horizon, I
We
know.
have been prevented. They did not allow us. That's why I'm on affidavit. If tomorrow it is proved that we were not prevented, your lordship can give us any punishment. But this is a fact. I am narrating to your lordship. Now, since I have read the Arabic, my lord, I can assist you in the proper way so that your lordship will resolve the controversy in right and legal perspective. Your lordship is before your lordship, my lord, because nobody has till date convinced your lordship, as my lord's honorable Chief Justice query was, how it is an essential religious practice. I have read the Quran. I can't say that I have a complete knowledge in the Quran. I'm not a Hifiz. I have not done Hifiz, but most of the Quran verses I know. This will enlighten to your lordship, my lord. Your lordship may kindly appreciate. Before your lordship are three important issues. Number one, to prove it from the verses of Quran that it is an essential religious practice. If it is provided in the Quran, then your lordships can agree to my submissions. Because where is the source? Source is, my lord, commandment from the Allah. There are two surahs. Your lordship can appreciate. One surah is Surah Nur, which would mean adornment, the beauty. That is why it is called Surah Nur. It is very important. Nur is adornment, a beauty. And then Surah Ahzab. These are the two surahs. Now the controversy regarding hijab. There are 4 kinds of burqa. One is a burqa. We call it a big gown, like a gown shape. Then another is abaya. It is covered, it's a long and having a very much gap. It would cover even the feet. That's called abaya. Then third is ihram. Ihram is only, my lord, at the time when Muslims would go and perform Hajj. That's also one of the body you can cover it. But as far as hijab is concerned, I will give the full background which has not been given by anyone till date. That's why you will also see the hijab is mandatory in Islam. How it is mandatory? It has come in the Quran. My lord, at the last, it's the last commandment from Allah. It has come in 4th Hijri. You will not note it down. In 4th Hijri, Hijri is 11 days less than 1 month. It has come in 4th Hijri. By that time, the Quran was almost complete. There was no such commandment from Allah till my lord, the 5 obligatories came into being. It came last in 4th Hijri. The first thing, it came after the first ordained, the first commandment from Allah is the obligatory daily 5 prayers. It's essential. 5 prayers. Nobody can say no. It's another thing whether all Muslims will go or not, that is something different. Then the second is, my lord, zakat. Zakat, I will translate it to you. If Muslim person is a rich, if there is any poor, irrespective of cost, you can give zakat to him so that he will be also financially sound. Then the third one is rulings of inheritance. In Quran, my lord, inheritance is also defined. We the Muslims say how much girl would be taken from the inheritance, how much share the boy will take. This is also defined in Quran. And this is obligatory religious practice. Then the fourth is fasting during Ramadan, as your lordships are aware. Fast is a compulsory religious practice. And there is also exception to fast. If somebody is old, infirm, or ailing, then he has to do it. But after he will recover from ailment, it is mandatory. Then 50 is, my lord, 50 is zakat. Of this is also very important.
What is fifth?
And my lord, till these 5, my lord, these principles were laid down in the Quran.
Which one?
There was nothing murmur. There was nothing mentioned in the Quran about hijab. About hijab, it was not till it came into being. The only thing, my lord, even after the commandment of Allah regarding marriage and divorce, these were the initial ingredients. This hijab came during
Sir.
the 4th Hijri.
Please.
Hijri is, my lord, a calendar month of, my lord, Arabian, different than Georgian. Your lords may kindly appreciate.
Sir, once again, sir, Honorable
Yes,
Court
yes,
wants
yes,
to know
please, please.
something. Honorable
Please,
Chief wants
please.
to know something.
Which was the fifth command?
Yes, 50 is, my lord. Yes, first is 5 times prayer, zakat, and Hajj is also there. Hajj. Your lords may kindly appreciate. How is hijab now? There is absolutely no, the word hijab is not in the Quran. I will give you, my lord, the very important. In Quran, my lord, the term hijab refers to a partition or a curtain, a sort of curtain. It's in Quran. In the literal or metaphorical way, it is a screen of some sort of partitions an individual from another. It is important to clear that hijab is mandatory, and even the wives of Prophet would wear it as mandatory. Same is explicit in Quran. Now I will read Surah Ahzab. My lord, Surah Ahzab, why I will read? This is very important to your lordship. I will be given permission to recite some verses of Quran also. I'm conscious that your lordships may not be in a position to understand the Arabic which I would recite to your lordship. But why I'm reciting? So that there will be a confidence and trust in me. I will not mislead your lordship. Being a senior advocate, I will try my best, to the best of my capability, to apprise your lordship about the Quranic verses. That is why I will recite Quran also to your lordship, so that your lordship will be having absolute faith in me, that whatever I am submitting, it's on the basis of the commandment of Allah in Quran. I will never mislead your lordship, so that your lordship will resolve the controversy in right and legal perspective. Now I will come to you. In our modern interpretation, nowadays we commonly refer to hijab as a scarf Muslim women wear on the head. But this is not necessarily the same used in the Quran. The term for head covering in the Quran is known as khimar. The khimar has further originated. This has not been explained to you, lordship. The khimar has, everybody said khimar, but where from it has come, I am highlighting that to your lordship. The khimar originates from the trilateral verb, khamna. Well, this is khamra. Your lordship may notice, I will give Khamara, khamra, which means gatha. Your lords may say Ghatta, gatha. And my lord, then another thing is very important, meaning thereby to conceal, hide or cover something. Let them wear khimar over the jayub. Jayub is a, my lord, covering the chest. In Arabic, we call chest as jayub. The spelling is Juyub. Jayub is originated from the Quran, and that would mean chest. You have to cover scarf, the hair, face, and chest to protect your privacy, to protect your modesty, to protect your chastity, and to protect your, my lord, all your Muslim values. Your lords may see. Then from the verse we understand that the believing women are instructed by Allah to wear the khimar to them, to drap it over the chest. But that is a real purpose. We have to cover three things, my lord in chest. We don't say that we will go in a burqa to the schools. Absolutely not. We would confine our arguments, my lord, the chest. It's a small part we are covering. The head, face, and the chest. These are all three vulnerable parts. My lord, vulnerable parts. So that there should not be an attractment. Unrightness people would gaze at the women, because these are very sensitive parts of the body of a woman. That's why in Quran, in Surah Ahzab, the Quran has revealed, it has been revealed to Prophet that you should ask your wives, ask your daughters, and the Ummah should wear it and cover. That is why, my lord, in Allah. Then in our common among us, the women of Jahiliyat, why I will give a background of this hijab. My lord, before the advent of Islam, my lord, before the advent, 1500 years before, during the Jahiliyat, we said intolerance time, when there was no existence of God, it was given by our Prophet. And that time, this practice was very much prevalent amongst the Christians. Your lordship would see, day in and day out, the Christians would also wear a type of burqa. And this scarf, head scarf, during Jahiliyat, even before the advent of Islam, was very much prevalent in Arab countries. And then they would call it, what they will say, it was commonly amongst the women of Jahiliyat pre-Islam to wear a head scarf. It was a bandana type. They called it bandana. Bandana type style of head covering that was wrapped and then thrown to the back. This was at the time referred to as khimar. However, when Allah revealed these verses and used the word khimar in the Quran, not then confuse the two styles of khimar. what Allah said. Allah instructed the believing woman to bring their fabric to their front by drawing their khimar over the chest as a covering. This is the nutshell. We have to cover the chest. It is mandatory. It's a question of life and death for us, my Lord. We don't want to destroy any secular service. How does it matter? I will come to that also, but let me approach your Lordship. Narcissistic ideologies are just that. Narcissistic ideological should be left there with the ignorant. The wearing of hijab is a commandment from Allah, our creator for the protection of believing women. My Lord, may kindly appreciate. We Muslims believe that this is a temporary right. Now I am coming to the verses of Quran, which I will narrate to your Lordship. To have a confidence, I know the Quran. I am the best person to my best ability that I will assist regarding the Quran, if it is an essential service or not. Then I leave it to your Lordship judicial wisdom. Your Lordship can see, this is the life temporary, testing ground to be far before us, pass on to the eternal life of the hereafter, when the ignorant make comments of possession because of the hijab, or believing women known as this is simple, not true. Your Lordship can see, why is hijab so religious practice? This I am giving, this has not been assessed to your Lordship. My Lord, in 621, our Prophet was taken during the night. He was taken to the before the Allah in the heaven. That is called the Isra. That's called Isra, Mi'raj. He was physically and spiritually taken by Jibril. My Lord, there was a horse specially designed for him by Allah. He had two wings, so that he will keep, a prophet will board, he will ride, and the two wings, my Lord, will have the balance in the air. He was taken by Jibril alayhi salam to Allah, to Almighty. During the journey, my Lord, it was one full night journey. During the journey, my Lord, he was supported at one place. He asked Jibril, Mr. Jibril, tell me which is this place. I have seen women crying. Who are these women? The Jibril has told him, this is narrated in Quran and in covered in the Hadith also. I will come to that. Jibril told him, Prophet Muhammad, these are women of your ummah who were seen not wearing scarf and not covering their head and chest. And Prophet was showing they were crying. There were serpents around their neck, around their hair. The Prophet said, I will pray to God, forgive them. They said, no, unless Allah will forgive, your prayers will not matter because they have committed a sin. So this is in our mind, my Lord, that we have to face the day of the judgment. And the ladies are conscious. We are living in a democratic country where rule of law prevails. Your Lordship has seen, your Lordship is son of the Indian soil. We are all sons of the Indian soil. Your Lordship has seen, the Muslim woman will be identified with the burqa. So it is not because of some compulsion. It's a religious entity. It's a sacred for us. And why? Your Lordship can appreciate. When this was narrated to Jibril, when Prophet came back during that night, he narrated to his colleagues. One of his confident friends, Hazrat Abu Bakr Siddiq, he said, I am weeping. Abu Bakr Siddiq said, why you are weeping? He said, I have seen the women from my ummah. They had not kept their private parts in that way in which Jibril has narrated to me. They were in really trouble in hell. So this is number. Now you Lordship can see. We believe in that we have to face the day of the judgment, the Muslims. That's why our women are very scared. It is not by way of fashion we are asking our women to wear. No, it is, Quran has said that it is at the time of first period or when you attain the puberty, you have to cover your sisters and daughters with a scarf. It's mandatory for us. Your Lordship can appreciate. I will narrate you two surahs, which are very important for your Lordship. Why I am narrating, I know your Lordship may not be in a position to, unless your Lords have read. I know my Lords are encyclopedia of every literature. My Lords have read. I read one surah, which is very relevant to this hijab. It's very important. My Lord, the God says, Sabi isma rabbikal ala, allazi khalaqa fasawa, wallazi qadara fada, wallazi akhrajal mara, fajalahu gusa'an hawa, san ukriyuka fala tansa, illa mashallah, innahu yahlamun jara wa ma yakfa, manu yashrikal yusra, fazakri nafati zikra, sayazakaru ma yaksha, wa yatajannabu halashka, allazi yasla naral kubra, summa la yumutu fiha, wala hayaha, qad aflaha man tazaka, wa zakara asma rabbihi, fasala bal tusiruna al hayatu dunya. Inna hazala fi subirullah Sufi Ibrahim wa Musa. Here he says, Qad aflaha man tazaka. Wa zakar asma rabbi fasalla fi dunya. Your Lordship, it is said that dunya is this world, is artificial, and better is the eternal life. So please don't carry the sin. The same way the fate has made by Hazrat Musa, Moses. and the Ibrahim alayhi salam. So please be ready for eternal face. Don't commit. This artificial life is only for 100 years, 60 years, 70 years. You have to face the day of the judgment. Please don't come. Then another surah is very important. It's a big surah, but I will cut short. It is said, I will read it, my Lord. Then another is Al-Hakumul Takasur, Hatta Zuttumul Mukabir. Mukabir is a grave. When you enter the grave, it means that you are accounted for your sins. The first question which will be asked to Muslim male or female would be, what was your religion, who was your prophet? And the lady will be asked in her graveside. This is our Quran, that whether you are following the Quran and the commandments or not. If it is proved that there was absolutely violation of Quran command, the lady will be sent there and that will help. My Lord, may kindly see. Then your Lord, may kindly. Another thing is very important in Quran, which I would like to narrate. My Lord, 2 essential religious practices are here. What is another, sir? Afala yanzuruna illa al-iblika fakulitat, wal samaika farifat, wal jibalika farifat, wal arzika fazakir inna anta muzakir, lasta alayhim bimusatir illa man tawalla wa kafar, fa yuzibullahu al-azab al-akbar, inna ilana ayyabahum, summa inna alana hisabahum. You have to give hisab. You are accounted for in the graveyard. At the day of the judgment, my ladyship may be in a position to understand. This is very important. It is correlated with our Lord. We have to be ready to face the day of judgment. Your Lords may kindly appreciate. To receive education is also religious practice for Muslims. To receive education also. And to wear the scarf, headscarf, to cover your hair is a really essential religious practice. How receive the education is essential. It is the Quran verses. Ikra bismi rabbikal ladzi khalaq. Khalaq al insana min alaq. Ikra wa rabbikal akram. Allazi alma bil kalam. Kalam means the pen. You please read and also to educate the people with the pen. This is the Quran. We have 2 essential religious practices. Number 1, to receive education, and number 2, my Lord. Yes, please, please, O Lord. Please.
Which
Please.
is at Shura, which we should note, because we do not know Arabic. We love to know, but we have
We
limitations.
try to understand you, but we could not.
But
Every feedback.
very
That is why
passionate.
I was, yes, for your Lordship is right. But that is why from the very beginning I was, because I had to insist, I'm a student of law. I belong to the fraternity. I will never mislead your Lordships. I will do the best of my Quranic.
We are not saying anything. We just
Yes.
want to note
Which
the
is the
surah,
Shura.
relevant surah, which makes.
Yes, I will give. Absolutely. Now, my Lord, may see, this is also. I narrated that, sir, your Lordship, that these 3-4 surahs, because I was compelled to say, your Lordship, that it is correlated to this issue. Because we are to face the day of the judgment, and particularly that is why we, from the.
Shura is.
I will give.
Yes, tell me.
My Lord, I will give definitely. I will give everything. Now, your Lordship, kindly appreciate, my Lord. After this, my Lord, no.
Along with the memo,
This is very,
what he is telling. I have with me.
very important. I am submitting to your Lordship. My Lord, we are in a democratic country. This where the
No, first
rule of
tell us
second-
Shura. We'll go to religion, then to the secular thing.
Yes. My Lord, Surah Ghashia is there. Surah Ghashia. Your Lordship say.
Surah Ghashia.
Yes.
Then Surah Isra is the Mi'raj, Surah Mi'raj, or our Prophet has traveled. That is called Isra in Arabic.
Isra.
Mr. Dar, you may give also the spelling.
Yes, ISRA, Isra, is meaning Mi'raj, Shabi Mi'raj. I have read almost all whole Quran. Yes, that's why I am assisting your Lordship in the right perspective. Then Surah Al-Ala. Surah Ala is the third one. Surah Ala.
Where have you mentioned in your petition? Just we want to note down.
Yeah, I have mentioned about the surahs. 2 surahs I have mentioned. Your Lord may see. My Lord may see my page. This I have said. My Lord may see para 19. Page 11. I will read that the right to wear hijab is an essential religious practice under Islam, as much as the same is the ordain of Quran and decree of Almighty. Allah and the state is not empowered to interfere with such rights, and Article 14, 19 and 25 of the Constitution of India. The impugned government order which declare that wearing headscarf is not protected under Article 2 is totally erroneous. and misconceived. Surah Ahzab, which I read to your lordship, which is quoted here. But I will then see the translation copy, my lord. Page 13, page 12. English translation for your lordship's convenience. Reference has been made to the Arabic term jilbab, which according to Cambridge Dictionary means a long piece of clothing worn by some Muslim women. It is worn over the other clothes and covers the whole body, sometimes include the head. This would indicate that the Islamic dress code for women not only consists of scarf that covers the head, the neck, and the bosom, but also concludes the overall dress that should be long and loose. According to the legend of Arabic, my lord, Arabic dictionary, jizab in this context refers to khimar or headscarf. This verse specially states that Muslim women wear the headscarf in order to be known and recognized in believing women and to be protected. Furthermore, my lord, then it is another Surah Nur. I have also translated copy, page 13. And tell the believing women to reduce some of their vision and guard their private parts and not expose their adornment except what necessarily appears thereof, and to wrap a portion of their head covers over their heads, chest, and not expose their adornment except to their husband, their fathers, their husband fathers, their sons, their husbands, sons, their brothers sons, their sisters' sons, their women, that which their right hand possesses, or their male attendants having no physical desire, or children who are not yet aware of the private aspect of the woman, and let them not stamp their. Then another translation copy. There here I would pause only for 1 minute. My lord. Your lordship may kindly appreciate. Yes. During the prophet's time, this is very important, which I am submitting to your lordship. During the prophet's time, when the prophet, this is my lord, a religion which is now having 2 billion across 57 countries, and we are proud to be Indian citizens because it's the second largest community in India. We would love to live in a harmony. We love to live with the brothers of majority. We have fought war together. We have fought independence war for constitution, established a constitution together. My lord, we can see when the prophet was spreading Islam, one of the community from Indonesia was predominantly a Hindu state, and my lord, on South African countries, they said to prophet, we will accept Islam, but with condition, because we have an essential religious practice, which we will not shun. We will not denounce that. Prophet said, which? They said, we will keep kundan. It's a Hindu right. We will keep kundan on our forehead and the long thread which the Brahmins would wear. Otherwise, that is not permissible in Islam. My lord may see, your lordships can check it on Google. Those people, all the Muslims except these Indonesians and the South African, they are being allowed by prophet. See the generosity of our prophet. How kind he was. He said, no problem. You can embrace Islam, come to Makkah, come to Medina, perform Hajj with the kundan on forehead. Your lordship may just open any time. We will see in the Hajj. Though this is not the Hajj period. Those people, they are still believing in Hindu faith, but they have embraced Islam because that was essential service. That was close to their chest. That was a life. But prophet said, no problem. You perform it. We are in a democratic country. But Sikar, if you make a public order, come on. Your lordship has taken it. My lord, Honorable Chief Justice and Honorable Justice Dixit story repeatedly to the lawyers. Please convince us on this. My lord, can you see that was the generosity of prophet? And now, my lord, may see how Sikar is essential. The another thing which I will narrate. Your lords may can see, we the Muslims are offering prayers. The ladies have a separate space. The gents have separate. We don't mix up together. We don't mingle up together. Then in Eid also separate. Your lords may can appreciate. Separate. But in Hajj, during Hajj, my lord, we perform together Hajj. We go circle 7, and that time it is mandatory for ladies to wear scarf. That is not exempted. Meeting together by men and women during Hajj was exempted by prophet. Not exempted during Eid, not exempted during Friday prayers, but during Hajj, my lord, ladies permitted, but they would keep ihram to cover at least 3 things, which is very important. Number 1, chest. Number 2, face. And number 3, hair, the head. My lord, these are essential which are performed during even Hajj. Your lordship can understand, my lord, from this. If it's a live example before your lordships, my lords can take judicial note of this, that even during Hajj, this is not exempted by prophet. Prophet said, no, The ladies and gents will be given this one the exception. They can perform Hajj together, but at the same time, they have to cover the head. So, my lord, on religious side, your lordship can appreciate that these are two surahs which are govern the field. There is absolutely no judgment till date from the Supreme Court or from any court why the hijab has not been. Contrary to that, your lordships are aware. I need not to explain that. My lords are aware about the Kerala High Court. That's a one single judgment, but principle has been laid down. Absolutely. Now the judgment is referred. I will now come to the constitutional aspect. The religious I have covered. Absolutely, I will give. And now, my lord, another thing is this, which I was about to forget. Now, there, my lord, we see page 16, page 15 of my petition, paper. My lord may say, apart from the Quran, which I verses, my lord quoted to your lordship and read to your lordship with my lordship's permission, that was the greatness. Now, my lord, we see para page 15. Additionally, another hadith reported in Tirmizi. My lord, we have three important books. Whatever is revealed in the Quran is the holy book. Then supported by three books. One is Sahih Bukhari, another is Muslim Sharif, the third one is Tirmizi. It's a collection of hadiths. We have to inculcate all these things by true Muslims, ladies and gents, my lord. And these are binding for us. Whatever Prophet has said is a hadith. And whatever Prophet has done is a sunnah. We have to perform that also. How can we skip? Then we are not true Muslims. And then, my lord, hadith is there, Abdullah, son of Umar bin Khatib, with whom Allah is pleased, reported that Messenger of Allah said, this is what how the Sahabis are. The colleagues were called in Islam Sahabis. On the day of resurrection, Allah will not look at the man who trails his garment along boastfully. Thereupon, Salma asked, what should women do with their garments? I have quoted this hadith. The Prophet said, they should lower their garments a hand span. Salma further said, women's feet would still be uncovered. The Messenger of Allah Sallallahu Alaihi Wasallam replied, let them lower them a 4 arms length, but not longer. This is number one. Then, my lord, we see another hadith. This is from Sahih Bukhari. I have cited Sahih Bukhari and why from Tirmizi and Muslim. These are three important sacred books for Muslims. In the event of infringement of dress code, punishment, which I recited to your lordship, is laid as now see the punishment for those women in Quran, in Hadith. This is, my lord, the translation. The people about whom evil fate, you should not feel sorry. A man who dissociates himself from the Muslim Ummah, disobeys the Imam, the ruler of Muslim Ummah, and dies at the stake in a slave who runs away from his master and dies before returning to him. A woman whose husband goes away after having provided her with, my lord, provisions, but she displays her beauty, and, my lord, during the absence, so do not concern about them. The my lord, jizab must concern the underclothes. Such requirement applies in the garment a Muslim should wear for salah, as well as he said. Salah means, my lord, and namaz we offer. There will be the later days of the Ummah. In the later days, women will be dressed and yet undressed. They will be wearing on these headscarves things resembling camels, humps, curse. Them they are accrued. Now, my lord, will see. Thereafter, these are the judgments we have quoted. I will now come. This is the religious point I have covered. It's absolutely, this is an, my lord, command from Allah. We Muslims have to follow if we have to lead a good life. And, my lord, tomorrow we should not be ashamed. If we'll carry these sins, nobody will atone these sins over our shoulders. The day of the judgment we have to face. That's why we advise our sisters, mothers, daughters to wear. I will come to the dress code also. Now, my lord, may see constitutional aspect. My lord, constitutionally, I have read a little bit constitution, my lord.
We have heard you on the religious point.
Please.
So far as the legal issues are there, they would be covered by the other councils who have already...
Briefly, I will cite 3-4 things have not been covered. That's why I'm giving trouble to you. Just 5 minutes. My lord, may kindly appreciate. The first thing is, I need not to refer the judgments, my lord. Your lordships are aware, are the masters of the judgments. Need not. Your lordship knows the law fully. My lord, may kindly see. As far as the protection of article... Please, my lordship.
We know only what you tell.
No, my lord. We always look to your lordship. Such a judicial wisdom. I will appreciate, my lord. I have 37 years practice at bar, but honestly, before man and God, I am just my lord, so pleased. The time your lordships have shown patience, absolutely, my lord, marvelous. Absolutely. Your lordship can appreciate what has happened. My lord, we have a protection under Article 25 of the Constitution. That's the main protection. And then we have a protection of preamble. Nobody has read that preamble. Your lordship, I will read the preamble of the Constitution because this is very important. Your lordship, I read the preamble. I read the preamble first. Nobody has touched this. Kindly see the preamble of the Constitution, my lord. I read it with my lord's permission. My lord may see, we the people of India, preamble of Constitution. This is very important. We the people of India, having solemnly resolved to constitute India into a sovereign, socialist, secular, democratic republic, and to secure to all its citizens, firstly, justice, social, economic, and political. The second is liberty of thought, expression, belief, faith, and worship. Is covered by preamble of the Constitution. I can understand, my lord, a student of constitutional law, my lord. This question was different in 1960 when a reference was made under Article 143 of the Supreme Court. In that reference, my lord, Bureau Burry's, my lord, union matter. At that time, my lord, the controversy was regarding whether the basic structures can be interfered or not. The position was still subsisting in 1967 when Gokalnath's scheme was, my lord, considered in that. So ultimately, my lord, Keshavan Bharti's judgment in 1973, it was, the field is covered by Keshavan Bharti's judgment. 13 judges, the honorable judges of the Supreme Court, delivered. You can't change the basic structure. How can it be done? And you will ask me, can see in Keshavan Bharti's judgment, earlier the controversy whether preamble is a part of Constitution, till Gokalnath's judgment, it was said it is not a part of the Constitution. But in Keshavan Bharti's judgment, it has been said it's a part of the Constitution. And when the preamble safeguards, it says that faith, it's a faith, it's a belief, it's the ordinance of Allah, it's a commandment of Allah. How can we forget Constitution of such a great country where we live in harmony? The people have shown the judgment from Tanzania, from South Africa, from America. What we have is a very small issue before your lordship. However, having wider repercussions, and the constitutionality your lordship has to be gone into. My lord, I can see, once it is protected by our own constitution, which is the constitution which is leading the entire country. We are such a country, my lord. Our economy is growing day by day. It is not that country where it's a banana republic. It is. We are proud to be having the largest democracy in country, my lord. We have a seed birth, permanent birth in the Security Council. That's our potential. We live in harmony. We live in brotherhood. Nobody. This, my lord, may kindly see. Your lordship is aware about Article 25. My lord, there are 3 conditions. I need not to read your lordship 1,000 times. 25 says health, public order, and morality. Scarf is a small issue. For such a big country, our heart should be open. It should be wide. We must be an open conviction for that. Please, this is not going to cause any effect to the health. Scarf, covering a chest, it gives, it purifies, it gives, my lord, modesty. It in fact enhances the reputation of a lady. Because the vulnerable parts, we are covering chest, face and hair. My lord, in this country where we have accommodated linguistic, my lord, people, different caste people are living in one family, in one home. Your lordship can see, it is not causing any immorality, my lord. Rather, it adds to the glory of morality. How it is concerned, article, condition number 1. Health, it doesn't cause any prejudice. Then it doesn't cause public order. What is public order? Your lordship can appreciate. There are 4 or 5 judgments which I will give to your lordship. Public order is, my lord, if with this putting a scarf, your lordship can appreciate. As my lord's suggestion was at one part time, asked Advocate General also. What is harm if same type of this small piece of cloth will be wrapped their head identical to the uniform or similar to the uniform? No heavens would fall. The mighty India, proud of its citizens, my lord. We love to our country. It will not fall. My lord, your lordship said, I was, my lord, watching the proceedings. Your lordship can see. Yes, how it will be public order? If you will put a scarf, will give bad image of Lord Buddha, of Lord Rama, or any goddess of Hindus. It will be in a mutilated form. It will hurt the feelings of other religion. Then it can be a public order. You are desecrating the image, the faith of other religion. Then it can be. If you are desecrating
anybody's, my lord, faith, or you are hurting his feelings, then it can be. But simple covering is judicial review power with my lords, unbridled, unfettered powers with my lord. How it is calling public order, I don't understand. Your lords are aware about the legal conspiracy. Public order is first is a law and order problem. You have a right. You have police apparatus. My lord, kindly appreciate. Yes, please, your lords.
Please show mercy to other friends also. There are many other advocates who have to argue.
Only 3 minutes. I will conclude in 3. But 3 minutes.
5 minutes. Now we have taken 10 minutes.
But 3 minutes
we
more.
have to discount.
3 minutes
We
more.
have to
I am
discount the hearing of your friends.
But 3 minutes
We
more.
cannot
I am
go
doing
on
only.
hearing like
Then
this.
I will not refer the books. Just 3 minutes. My lord, accounted me for 3 minutes more. My lord, may kindly appreciate. This is that.
Each minute is
My lord,
beyond 60 seconds.
No,
That is
just 3
problem.
minutes. I will keep mum after 3 minutes. That's why lord's greatest. My lord, I have said that it doesn't fall within the conditions. Preamble is quite clear. There is no condition. And wearing a hijab is a normal thing.
Yeah.
It doesn't hurt any feelings, anybody's. Now, my lord, may kindly appreciate. There are judgments. I will read these judgments to your lordship. Only quote these judgments on public order, and then there is a guarantee. The very first judgment I would like to show to your lordship is.
Give the citation.
Yes, only citation.
Give the citation in paragraph. Please do not read.
Paragraph
Read
and
them.
citation.
We be assured that.
My lord, Ram
Give us
Manohar
one.
Loya versus State of Bihar. Ram Manohar Loya versus State of Bihar. AR 1966. Supreme Court cases 740. Para 55. This number 1 judgment, my lord, I will give. Another judgment, my lord, is on public order.
Yes.
It is an Adyatan, my lord, versus Travancore Devasam Board, 2002, my lord, Supreme Court cases, page 106, my lord, para 16.
Volume?
Is also in AR 2002, Supreme
Which
Court cases.
volume? SCC,
Yes,
which volume?
it is, my lord, volume 8.
8.
Volume 8. It is also reported in AR 2002, Supreme Court 3538, and para is 16. The second, then my lord, the third judgment which I would like to on public order is Church of God in India versus KVR, Master Colony Welfare Association. It is, my lord, reported in 207, volume 7, 2000, my lord, sorry, 2000, volume 7, Supreme Court cases 282. And another judgment is, my lord, is Commissioner of Police.
Page
versus-
282.
Yes.
Volume
It is
7. 285,
my lord.
At least here you have to be first now.
282.
Reason you can be one first line.
Para 2, my lord, para 2. Then, my lord, Commissioner of Police versus Jagdish Varande. It is 2004. 2004. My lord, volume 12, Supreme Court cases, page 770, and page is 778, para 9. It is said, my lord, it doesn't confine only matters of doctrine of belief, but also extend to acts done in persons of religion, also include relatives to the rituals. Though our is an essential religious service. Rituals are being covered by this constitutional guarantee. Then another judgment is last judgment, my lord, which I would like to submit. And then I will conclude with by summarizing. Then it is, my lord, one more judgment is there. Your lordship may say, it is, my lord, Dara Singh versus Republic of India, 2011, SCC, page 499, and para is 531. I will summarize within one. My lord, now before your lordship, my lord, this is the marginalized community as far as education is concerned, my lord, because of our own faults. We are giving contribution to our big brothers, the majority. We live in harmony, we live in diversity, and your lordship may come down to that extent. Please allow our girls to cover their heads. It's not going to cause any big prejudice to anybody, nor. And my lord, the scene was created by those. My lord, this is your lordship. In this country, rule of law will prevail. This is not a Hindu Rashtra. This is not an Islamic Republic. It's a democratic, sovereign, secular country where the constitution is the supreme. Majesty of law will prevail. All times to come. We will not, from our community, it is the same community, my lord, where Allama Iqbal has said, "Sare jahan se acha Hindustan hamara. हम बुलबुले हैं इसकी ये गुलिस्तान हमारा मजहब नहीं सिखाता आपस में बैर रखना." What a beautiful, this is the community which has produced Kalam Sahab, who was the master of well-armed missiles. We are well working
We live in harmony. Please come to our rescue. And the
All right,
interim order is mostly unconstitutional. My lord, because it is suspending the constitutional guarantees. The parliament has no power even to, my lord, suspend or to repeal the basic strictures. And even the state legislature does not. They don't possess any
Yes, we
power
have
for that.
noted,
With
Mr.
all
Bharti has
humble
noted.
submissions,
Thank you so
I would
much.
like to request your lordship may dispassionately consider this issue, because this is a question of life and death for us. Either we have to leave the education because we will not compromise with our principles, and we have to complete it. We are ready to leave the education if your lordship will not come. We are before the my lords. After divine is my lords which have been. That's why we call your lords lords. You have all the powers, but the best word on earth. My lords are before my lords. We call them that you have been best word, clothed with such powers, come heavily on the state. How come they can ask this government order, which runs contrary to the mandate of Constitution, which overrides it? This is all submission with my lords. I'm
Thank
grateful.
you.
Your lord.
Thank you.
Next
Thank you.
matter, number
It was like Antonio's speech in Julius Caesar.
Grateful.
Yes.
My objection.
Kindly, petition 3942, not 175 minutes, delay, my lord, I was. It was whispered before I make my submission within 2-3 minutes and give it to you. It is recorded as.
All right, wait. Don't write that order which you have said on 3942. Yes, this 4311.
Just like to bring the notice, my lords. Only some paragraph of Quran, my lords, which is related, wherein
This is
I can.
4311. You are appearing in 4311.
Yes, my lord. My lords, only I can prove that it is an essential part of Islam. I have the Quranic version, my lords, where
there are some office objections there in this.
my lords, it will become. My lords, only just I need 2 minutes. Only.
No restriction placed upon them. Whatever restriction is placed by the student, the same is there. Already order has been passed. That is the petition where time will do the petition. That's in that they have already passed an interim order in respect of this very.
My lords, it may be connected with that, my lords. Only for the assistance of this court, I have filed a memo, my lords. I'm submitting the memo just to bring to the notice of this honorable court some Quranic version, my lords. So then my petition may be connected with that learned honorable single judge, my lords, where the right petition is connected with. Only to bring to the notice of this honorable court, I have brought some Quranic versions, my lords. It may be kindly heard.
What he said.
It has to be connected with some petition.
Yes, my lords. It may be connected. It is to be connected, my lords, with the single. Only I have submitted the memo, my lords. I want to bring to the notice of this honorable court some Quranic version where it shows it is very important, my lords. That's all. That is my submission, my lords. I want only 2 minutes, my lords, to explain.
That petition is not before us.
That petition is before you. That petition was, my lords. He withdrew. Mr. Tahi withdrew.
Withdrew it, you want to get it connected with it.
No, my lords, my submission is that when I have been.
Two petitions is filed. One before the learned single judge. One before your action, the same petition.
No, today he withdrew 2 petitions.
One petition relates to other institutions. They are not concerned. So far as the learned institutions, college, that is not connected to which petition number. 2902 of 2022, which is presently pending before the learned single judge.
Here, my lords, the respondent Bandaskar College, they have permitted me from the time of admission to wear with the headscarf. I was allowed. The commissioners were allowed to wear headscarf. Now, when this issue raised, the commissioners are restrained from entering into the even into the college with the headscarf, my lord. So that was my contention. It is a degree college. The petitioners are degree students, my lord.
Let that be, this be connected with that petition?
Yes, my lord. It will be connected with that petition.
All right. Counsel for the petitioner.
My lord, I may be heard, my lord. I want to quote some Quranic versions, my lord, which are not been brought to me, but only just 2 minutes, my lord.
1 second. We are passing order. similar matter is pending before the court in WP number 2902 of 2022. This matter may be connected, this case may be connected with writ petition 2902. The office may list the case along with WP number 2902 of 2022.
Lord, I have a memo, my lord. It may kindly be considered, my lord. Only 2 minutes I require the time of this honorable court so that I can show the court.
Argue your case when your case will be taken up. That is all.
That's all. Just I want to submit that according to the any rules is made up in the country, my lords. If a person
Not like this. It is enough.
1.12, Amritesh NP.
15 objections, including fees. It's not fair.
Who appears?
NP Amritesh. Subhash Jha.
Yes, yes, my lord. Which is it 4338 is the petition?
4338.
Yes, yes, my lord. But I beg to appear for the petitioner.
If you have not paid the court fee, without fee, we will not touch the papers.
Lord, I undertake to pay it, my lord, during the course of the day, if permissible, or latest by tomorrow.
But our court fees act does not permit.
But, my lord, this can be dispensed with, my lord. Of course, my lord, I leave it to the court. I can't, my lord.
No provision in the court fee.
My lord, we had checked it, my lord, with our counterpart there, and we were told.
Not only court fees, 14 objections are there in the petition.
We had sent it online. It was online filing.
That is the problem. And then you have not checked it, the objections, and you have not got it removed. The objections have also put on online.
Lord, subject to office objections, my lord. If your lordship could permit me, my lord, to address.
Can be permit when the petition is not maintainable. It is not maintainable without court fees, without fulfilling the requirements of the writ petition.
My lord, these are, of course, my lord, I can't, my lord, say anything beyond this, that, my lord, these are the rules. And if, my lord, ultimately, if certain relief, which otherwise the petition deserves to be granted, my lord, may not be denied to him only on the payment of court fee, subject to, my lord, clearing the office objections by tomorrow. It may permit, my lord, us an audience today. Because, my lord, your
We
lordship,
can grant you time to make good these objections, that is all, if you want.
Yes,
Otherwise, we will have to dismiss the petition.
your lordship may do it, my lord, your lordship may have it tomorrow then in that case.
Counsel for petitioner, place for is allowed a day's time to make good the office objections. Put up tomorrow. So that is the end of the petitioner's side. We will start with the rejoinder, Mr. Devdutt Kamath.
Yes, my lord.
You please start the rejoinder.
Yes, my lord. I am grateful.
Arguments on the petitioner side.
Yes, my lord. My lord, lords, we have heard, my lord, really scintillating arguments, my lord, from my learned senior colleagues, my lord. And I must say, my lord, as a student of law, my lords, I have been greatly enriched, my lord, by the range of arguments, my lord, which have been placed at the bar.
Yes, we have also learned a lot.
My lord, that I, my lord, lordships are, my lord, repository of wisdom, my lord, that I don't agree, my lord, as a member of the bar. Lords, on that, my lord, I'll put a caveat. But from my side, my lord, it's been a learning process. My lord, on a lighter vein, my lord, I feel that I am like a batsman, my lord, who has come now. And my lord, there have been fast deliveries, my lord, which have been bowled on both the sides, petitioners as well as respondents.
You were the opener.
Yes, my lord. And my lord, I have to deal with them. Some are, my lord, good length deliveries, which I will deal with, my lord. And some are, in fact, my lord, wide deliveries, submissions made on, my lord's ERP, etc., Lordships will have to actually decide whether they actually fall for consideration. And I'll point that out. And some my lords, I must say, are no balls, probably inadvertently made, dissenting judgment cited, overruled judgment cited.
Some
On a lighter vein, my lords.
There should be some humor in the court hall
Yes.
also.
I am not objecting, but I am saying, my lord, that. So I will deal with all this, my lord. So let me start with, my lord, my petition, which is, my lord, writ petition 2880. And, my lord, I appear only in this writ petition. Lords, I don't represent any PIL client. I'm not representing any community. I represent the petitioners as far as writ petition 2880 is concerned.
Yes.
And, my lords, in my writ petition, to which there is no reply, we are almost, my lords, 10 days in the hearing.
No, they have adopted that reply to all the petitions.
My lords, in my case, I have specifically pleaded in paragraph 6, page 5, that we have been using a headscarf right from our admission till, my lords, the GO came and we were stopped thereafter. I just want to point out that there is no reply rebuttal in specific as far as this averment is concerned. Lord,
Paragraph 6.
Paragraph 6, my lord. Another paragraph also, not trouble your lordships with that. That's point number 1. Second, my lord, this is a co-ed school. My lord, co-ed college.
When you were admitted.
My lords, this is in the, we are, my lords, in the second year of the college.
Since their admission in the respective colleges.
Yes, my lord.
You have not disclosed as to when you were admitted.
Lords, that is true, my lord. But since their admission, my lord, is 2 years. But lordships will see, we were admitted 2 years back.
First petitioner was admitted is in the first year PUC, second
Yes.
petitioner is
Yes. So, my lord, the second point which I wanted to make is kindly see my reliefs. My lords, I have not asked for a general declaration that wearing a headscarf is a part of ERP, a mandamus. I have primarily attacked. Yes, my lord.
Quashing of government order.
That's right, my lord.
Coupled with mandamus to them to permit you to wear hijab and
Yes,
enter
my
the.
lord. Yes, that's all.
Next.
I'm grateful for that, my lord. Because, my lord, quashing of the government order, according to me, would result, my lord, in the eventual outcome. Prayer 2 is only consequential. So my primary challenge, my lord, is to the GO.
Yes. Next.
Now, my lords, kindly turn to the GO itself. And I will not, my lords, go by, lords, what is the correct translation, etc. But just have a look at, my lord, the list of documents which have been submitted by the learned AG, and we'll go by that. Just now, relax, don't interfere. No, there's a list of documents. I think it is 47 pages, which was handed over by, my lord, sir, my learned colleague, my lord, the learned AG, my lord. And if I can just place the GO itself, which is at page 39. And I must say, my lord, that much of my task as far as this GO is concerned has become very easy because 90% of the GO has been given up by the learned AG. And I'll show that. Now kindly turn to page 39. Has been conceded, my lord. The Kannada translation starts, the Kannada version is at page 39 and the English version starts from page 42. My lord, the Chief Justice got it, my lord. My lord, Justice Kazi also has it.
Yes, page 23.
My lord, page 42, my lord, is the impugned order. 42. I'm so sorry.
Yes.
Page 40, page 42 are the recitals, which are not trouble your lordships. Page 43, my lord, are those three judgments. My lords, one Kerala High Court, then my lords, one Bombay High Court, and last, my lord, one Madras High Court. And then, my lords, over the page is the understanding of the state government that as per the judgments, directing not to attend school by wearing headscarf or covering head is not in violation of Article 25. Now, my lords, the learned AG, in all fairness, my lord, on the first day of opening, has clearly said, my lord, and I have noted down not once but 3 times, I've got the transcripts also. He has said that as Advocate General, this is not the purport of the order. This may have been a result of a little over enthusiasm. That are his submissions, my lord. And he has said that it may not have been required. So, my lord, my primary emphasis in my opening was this understanding of the state government in the GO was totally flawed, inter alia, for various reasons. Firstly, I said these 3 judgments do not say that headscarf is not a part of Article 25 right. Now that has been given up by the AG. Number 2, he kept saying, my lord, till the end, and I observed him, heard him very carefully, I will explain those judgments. Till the end, my lord, those judgments, 3 judgments were not explained by any of the council. So, my lord, this part of the GO, according to me, has to go. Second, even if your lordships were to discard the concession made by the AG, this portion of the GO also has to go because it offends the doctrine of dictation in administrative law. Lordships knows, my lord, I don't want to cite judgments, but when a superior authority, the state master, tells the subordinate authority, you do as you want, but I think hijab is not a part of Article 25. That's what this GO says. He says operative portion is innocuous. Master is saying, you decide as you want, but I think, hijab is not a part of Article 25. I say, my lord, in administrative law, this is not permissible. And I don't want to cite judgments, and I'll just give the paragraph numbers, my lord. Just have, my lords, volume 3. If my colleague Shahul can hand over, I'll just give the paragraph. I'm not going to cite it. I'll just give the paragraph numbers of the judgment. Lordships may just make a note. I'm not going to cite because I'm on very limited time. Shahul, if you can just hand over that compilation.
Anyway, acting under dictation.
Yes, yes.
Standard pattern in all administrative law by Jain and Jain.
That's right.
IPMSC.
I'm grateful, my lord.
Basu also.
Lord, showing these judgments is bringing coal to Newcastle, my lord. I am like a lamp trying to, my lord, before a blazing sun, my lord, trying to show a wave a lamp, my lord. It's totally inappropriate, but I have to do my justice, my lord, as an officer of the court. So I just wanted to cite these judgments. Lord, lordships will just have a note. Serial number 1 is 1973 SCC, page 76. If the court master can just hand over that compilation so that the honorable court can just mark it. Because on the index, your lordships may just mark it and leave it, my lord. My lord, serial number 1, 1973 SCC, page 76, paragraph 4, my lord, running page 3, and my lord's item number 4, para 23, page 96. That's all, my lord.
Yes.
The third reason, my lord, why this penultimate part has to go apart from concession, apart from doctrine of dictation, is that there is no material. If the learned AG's stand is these judgments are irrelevant, then what is the material to arrive at this prima facie understanding that hijab is not a part of 25? So therefore, my lord, Article 14, Nagraj jurisprudence will come in. That every administrative decision is not ipsy dixie of somebody, some undersecretary, his understanding. It has to be based on material. So Article 14 is clearly offended. So, my lord, those are the three submissions as far as, my lord, the penultimate part is concerned.
Yes.
Now, my lords, we come to the operative part. Now, my lords, the first part of the operative part, I am not concerned. Second part, let's read it, my lord. It is ordered that in colleges under the jurisdiction of the Department of Pre and University Education, I'm sorry, my lords, I was reading page 44, my lord, of the GO. The uniform prescribed by the College Development Committee or the Supervisory Committee of Management of the respective college shall be worn by the students. If no uniform has been prescribed by the management, then the students shall wear that dress, that goes well with the idea of equality, unity, without affecting law and order of the region. Now, my lords, as far as this line is also concerned, the learned AG, my lord, I've got the transcript. He says last three lines were unnecessary. It was not required. And that part also has been considered. Although, my lord, the original lordships have seen Sarvajanika Suvyavaste, it actually means public order. Lord, that has been, my lord, kind of diluted. This one says law and order. The learned AG says, no, I don't need it. In fact, my lord, in the affidavit which they have filed, they say public order. Lordships may make a note. In the affidavit which they have filed, I'll give the paragraph number. Lordships may not be troubled, but paragraph 15 of the affidavit in 2146 of 2022, the affidavit filed by the state, paragraph 15, Lordships may make a note, says that they are doing it on the ground of public order. So, my lord, we have a version, we have a public order ground which is there in the GO, given up by the learned AG in the arguments. In the translated version, a definition which is against the constitution is put. In the affidavit, public order is reiterated. I say, my lord, is this the way a government order is read? So kindly see in that light, my lord, Mohinder Singh, is this at all permissible? Lord, that
yes, we have seen 1978 Supreme Court 851.
Yes, my lord.
We know that.
Yes, my
Go to
lord.
next point.
Just, my lord, just one line in that. Just have a look at, my lord, that compilation which I have handed over. In that, my lord, lordships are aware. Just have a look at paragraph 8. And, my lord, I'll rest my case with that. Just have a look at paragraph 8 at page 17 of this compilation. Justice Dikshit, my lord, has been saying this from day
I have
one.
read that judgment any number of times. Kindly tell me, I can reproduce also.
Yes,
Please read.
Yes,
I know that.
Yes, my lord.
Yes.
Public orders. Lord, that it's a extract of the observations of Justice Bose in Gordon Das Bhanji. Public orders.
52 Supreme Court.
Yes, my lord.
1952 Supreme Court, page 16.
My lords, I am literally amazed. My lord, I am literally amazed, my lord. At our age, my lord, we don't remember citations. Your lordships, my lord's memory is phenomenal, my lord. That's something which is God's gift.
Even tolerance also.
Yes. It's God's gift, my lord. Everybody can't have it, my lord. We may learn, but these things are God's gift, my lord. Public orders publicly made in exercise of a statutory authority cannot be construed in the light of explanation subsequently given by the officer making the order of what he meant, of what was in mind, what he intended to do. Public orders made by public authorities are meant to have public effect and are intended to affect the actings and conduct of those to whom they are addressed, and must be construed objectively with the reference to the language used in the order itself. So therefore, my lord, on the last part, that now the AG says that there is no public order. It is not a GO based on public order, because I had made lengthy submissions, which I will not reiterate, that public order cannot be a facile ground. State cannot say that I want to exercise my fundamental right, heckler's veto. I have cited all those cases. That public order ground has been virtually given up. Right, my lord? Now we'll come to the point of whether these college development committees, which I refer to as the MLA committees, my lord, have the jurisdiction to, my lords, undertake this exercise as is contemplated by the GO. And your lordships put, my lords, searching questions to us, both to this side as well as to the learned AG. And the learned AG says that, look here, this is Westminster model. MLAs are there, they're public representatives. What's wrong? I say, my lord, everything is wrong. We don't have to go to Westminster. Please have a look at section 143 of the Education Act. So lordships will recall the CDC was a committee which is constituted by the circular of 2014. And I am not challenging the circular. I am challenging the investing of executive functions, statutory functions to this CDC by this GO, that operative portion, which asks the CDC to perform certain functions which are exclusively there for authorities under the Act. Now see, please see page 143. Sorry, my lord, section 143. The state government, my lord, the Chief Justice has it, my lord? Yes. The state government may by notification in the official gazette. Lords, I can't make a statement whether this has been notified. So that, my lord, the government has to say. The state government may by notification in the official gazette delegate all or any powers exercised. Yes, sir.
This point is covered by Professor Ravi Verma Kumar. Only repeat.
Yes, no, I'm saying something else.
It cannot be relegated to other than government officers. Because the section says that.
That's right, my lord.
Therefore, we can go.
Yes, my lord. So I am saying, my lord, kindly see if any as may be specified in that direction to be exercised by such officer or authority subordinate to the state government. Now I say, my lord, that an MLA is not an officer. Is not an officer subordinate to the state government, and that is covered, my lord, by a judgment of the Supreme Court in Ashwini Kumar. Lordships knows it, but lordships may just make a note in that compilation which I have handed over. That is, my lords, item number 6, Ashwini Kumar Upadhyay versus Union of India, 2019, 11 SCC, page 683. Lord, that judgment starts at page 117 of this compilation. And my lords, lordships may just make a note, para 15, page 129.
Yes.
Between, my lords, placitum D and E.
We have followed that judgment.
Yes, my lord.
We have already followed. The division bench has already followed that judgment.
I'm grateful, my lord. Lordships are aware, then I'll not labor on this. Lordships may make a note. Yes, I don't want to labor on this. The lordships are already aware of. So, my lord, lot of arguments have been made while we are on this, my lord, that I have not challenged the circular. I don't need to, my lord, of 2014. all of the learned counsel who have appeared, lords, have said, where is the challenge to the circular? Mr. Puvaya said it, learned AG said it. I don't need to challenge the circular. As long as the circular, my lord, which prescribes the CDC remains a Margdarshak Mandal, I have no difficulty. Let them guide, my lord, the college, no difficulty. Let it be, my lord, a guiding force. MLAs, my lord, guiding a college is a good thing. But the problem happens when, my lord, you invest them with statutory functions. So therefore, my lord, as far as this GO is concerned, I respectfully submit, my lord, on all counts, this GO cannot stand, whether the penultimate part or the operative part. And therefore, my lords, I say that this GO has to be quashed. Now, my lords, if the GO goes, I respectfully submit, my lord, that there is no restriction ipso facto on the exercise of a fundamental right under Article 25. My lords, I wanted to develop this argument. My lords, I'll subject because already 4:35, my lord, either today or tomorrow. Because I want to say, my lord, that this question, and I'll just place the proposition so that, my lord, I start from there. And the proposition, my lord, which I want to place, because, my lord, judgments after judgments on ERP have been cited without actually, my lord, telling your lordships, when does the stage of ERP actually come in a constitutional adjudication? And that I want to address. And I want to place, my lord.
1 second, Mr. Kamath. We have read proceeding rules 1977.
Yes.
3 division bench judgments of this court have held.
Yes.
In reply, you cannot raise a new ground.
No, I'm not
you
saying
only respond to this one.
I am only responding, my lord.
Lies.
I'm only responding to judgments after judgments on ERP. And I am saying, my lord, that ERP question was raised by us only as an attack on the GO. The GO falls, matter ends, my lord.
Okay.
But since this ERP has been raised, my lord, and so many judgments have been pointed out to your lordships, it becomes my duty as an officer of the court to point out the context.
Let's give in writing whichever you want to say.
When you say that if this government order goes, there would not be any restriction in exercise of fundamental rights.
Yes, my lord, I'm grateful for that.
What is that fundamental right which you want
yes,
to
my lord,
exercise?
that's what I want to say. My lord, just give me 2 minutes, my lord, I'll start tomorrow. Lords, what I want to say is this. The question of ERP...
You finish it today. Finish it today.
Difficult, my lord. Lords, I have your lordships have given
We
you...
will extend our sitting. We will extend our sitting. You finish it today.
Up to your lordships, my lord. My lords, we are here to assist.
Because we have the experience. We gave you once time. Then next day you take 2 hours.
No,
Said 10 minutes. So this time we will not make that mistake.
Lordships are kind enough, my lords, and patient, my lords, in bearing with us. Yes, my lord. My lord, sir, then I will take at least half an hour.
One request we have, Mr. Kamath, we have, you said special bench which Honorable Chief Justice.
I know, my lord. I know, my lord.
We have tremendous pressure of work on individual side also.
I know, my lord. I know, my lord.
Therefore,
I will not repeat.
We will treat every point. Take it from us. Every point which you have said.
Yes.
We shall be.
I have absolutely no doubt.
Not duplicate and repeat.
No, I will not repeat. I will not repeat.
1.5 days you have taken.
Yes, no, but
1.5, not only before me, even before the division bench. There are rest of the people confined to this.
In rejoinder, my lord, because a lot of interesting points, my lord, important points have been made by the learned AG. I want to rebut that. Now, my lords, on 25, on ERP, I have to say this, my lord, that ERP stage, my lord, does not arise in this particular case, and I'll make that good. My lords, when a challenge is made before your lordships that Article 25 right is violated, the first, my lord, question which your lordships will ask to the state is where is the restriction? Once there is a valid restriction, a valid law or an order under having the force of law, the second question arises as to whether that law or an order having the force of law impinges upon an essential religious practice. So it's the second stage of scrutiny. I am saying, my lord, that the state has not satisfied that the first threshold has been crossed. Now the order has gone, my lord. What remains is Rule 11 of the Education Act.
95 rules, 96.
Yes, my lord. Yes, my lord.
95.
Rule 11. And the question, my lord.
How can you insist wearing hijab inside the institution which
Correct.
has prescribed certain uniform?
Yes, yes, yes.
Now
There's
you
no
say that you have a fundamental right.
Yes.
Now, what is that fundamental right? This is what we want to understand.
I'm grateful, my lords. I'll endeavor to, my lords, assist your lordships on that. Lordships will kindly see that the Education Act and the rules, my lord, at the most, as per the state, my lord, is covered under Article 25(2)(b). That kindly have a look at 25(2)(b), my lord. And that's a very important question which has fallen from the Chief Justice, and we must answer it. Kindly have a look at 25, my lord. This is not a case of lordships have seen this again and again.
Article 25.
Yes, my lord.
Yes.
Lords, this is not a case of 25(1) because the learned AG himself has not put it on 25(1). Although, my lords, Mr. Venkatramani put it on 25(1). Mr.
No, first you have to establish your right. First you have to forget about what AG has said, what the state is saying, or what other respondents are saying.
That is why I am just going to
establish your right.
Yes. Lords, kindly see. Lords, I have to first, my lord, satisfy your lordships. What is the scrutiny which your lordships will do? Your lordships will not ask, my lord, where is the right? Because Article 25(1) is a
No.
right.
You are insisting.
Yes.
You are insisting to wear particular headdress inside the institution which has prescribed a certain uniform, which does not prescribe the headdress. Now you say that I have a right to wear this headdress because I have a fundamental right.
That's right.
Now we want to understand that fundamental right. You have to establish first before the court as to what fundamental right is being infringed.
I'm grateful, my lord. I'm grateful.
Yes.
So kindly see, my lord, I will cite only 25(1). And actually, my lord, since this very right has been questioned, I didn't, my lords, actually expect the state to question that right. But since that right has been questioned, I will point out from the Constituent Assembly debates this uniform issue.
We said you forget about the state.
Very well.
What stand the state is taking, forget about it.
Yes. Since this
you first establish your right.
Yes.
If you are saying that under Article 25(1), you have a right, then first show that.
Yes. Kindly first see 25(1), my lords.
Yes.
25(1), subject to public order, morality and health, and to the other provisions of this part, all persons are equally entitled to freedom of conscience and the right freely to profess, practice, and propagate religion.
Yes.
Now, my lords, this includes essential practices, non-essential practices. Lords, on concepts, I have to be clear. The right, my lords, under 25 is a canopy of rights. I may not even have a religious right.
Again, these are two things.
Yes.
It is the freedom of conscience and practice of religion.
Correct, my lords. Correct.
Religious practices.
Yes.
Now, which one you are insisting?
Lords, I am saying it is a part of religious practice.
Religious practice.
Yes.
Now you say it is part of religious practice.
Yes.
Now you will have to establish that it is part of religious practice.
My lords, before I do that,
you are not on freedom of conscience. You say that wearing of headdress is part of religious practice.
Correct.
Then kindly establish that.
Yes, my lord. My lord, I would like to slightly differ on your lordship's approach, because before your lordships question me, where is my right? I ask myself, my lord, where is the restriction? Because 25.2 is very clear. What can be restricted? Just have a look at 25.2.
No, we are not talking about any restriction. We are just talking about your right,
My lords,
which you are insisting for, which you have come before the court.
That's my right flows from the Quran. I will come to that. But I am saying, my lord,
You said that it is not an essential religious practice. It may not be necessary to establish that it is part of essential religious practice. That is why we want to know actually what right has been infringed.
My lords, before you come to the right, because in an inquiry, my lords, whether a right has been infringed or not, before seeing the right, my lord, your lordships will have to see whether there is an infringement in the first place. Then the question will come whether it is infringing an essential part or not. Kindly see, my lord, that has been the approach of the court. If there is no valid restriction, my lords, I can't as a private person stop somebody from exercising his religion.
It is a institution which has prescribed uniform.
No, but
these students are supposed to wear a particular uniform. You
no
are
difficulty, my lord.
insisting to wear
No
more than
difficulty, my
that.
lords. No difficulty. But I am not able to express myself clearly. The submission which I am making is this, that if there is no law providing for social welfare and reform, just have a look at, my lords, 25.2. And that will probably, my lord, that the question which has fallen from the Chief Justice is very, very important. Just have a look at 25.2, my lord. Nothing in this article shall affect the operation of any existing law or prevent the state from making any law. No difficulty. For what? Providing for social welfare and reform. So the question which will arise for your lordship's consideration is the Education Act and a rule which is made under the Education Act prescribing uniform, is it a measure of social reform as far as Islam is concerned, as far as hijab is concerned? Kindly see this, Lord. This is I am making a submission. Please.
No, it will not be attracted. It will not be attracted.
My lord, if there is no 25.2 law, my lord, kindly see, I'm grateful for that question. If there is no 25.2,
it is reformatory. The
I just
Article
want to ask that.
25.2 is a reformatory power which has been given to the state government.
My lord, it's
for
not
certain
that,
purposes. It is not for the purpose of enacting any education act or something like that and prescribing the uniform.
Yes. My lords, in fact, I'm grateful for that question. My lords, in BJ Emmanuel, because my lord, there are cases and cases. In BJ Emmanuel, my lord, the very same argument that look here, it is a reform, Education Act, the same act. My lord, if at all there was any case before your my lords, if there was any case, my lord, which actually fits in teacher situation, Education Act, students, discipline, and my lords, the argument of reform, national integration, fundamental duty, and the student saying, I don't want to sing the national anthem. It's a part of my conscience right. The question which the Supreme Court asked, my lord, in that case is not to the students. Show me it is an essential religious practice. And I want to show that. Because the law, my lord, has been totally inversed by the state. In BJ Emmanuel, the Supreme Court didn't ask the students, show me your right. I want to show that, my lord. That's very important. The Supreme Court asked first, where is the restriction? If there is no restriction, there is no question of getting into ERP at all. Because ERP is not a restriction on my fundamental right. ERP is a restriction on the state's right under 25.2. That concept, my lords, I have to make it clear. ERP, my lord, in any of our Supreme Court judgment has not said, and I will cite each of those judgments. ERP is not a restriction on fundamental right under 25.1. That concept, my lord, is totally wrong. ERP is a restriction on state's power to interfere with a religious practice. So therefore, my lord, the question which should fall, my lords, according to me, for consideration first is, where is the restriction? And my lords, throughout my learned friends,
What is that restriction? Honorable Chief Justice was repeatedly.
yes, there is no restriction according to me.
Restriction means
Yes,
restriction must be not in vacuum. It has to be on somebody's right.
correct.
You have come to report complaining.
Yes.
Your rights guaranteed that are otherwise guaranteed under 25.
Yes.
Be it according to them, one whatever, or infringed. Honorable Chief Justice is saying.
Correct.
When you speak of restriction, certainly it is not in vacuum.
Yes.
It is with reference to a right allegedly violated.
Yes.
That is, where is your right is the question. That is how they have started. That clarification Honorable Chief Justice wanted.
Grateful.
That you have to clarify.
Yes, I'll clarify that. I'm grateful for that question because that's really the heart of the case. My lords, 25(1), my lords, is not a restricted, my lord, a paradigm, my lords. The canopy, the width, and the ambit of rights is not capable of putting in a straight jacket formula. That is, my lords, 25(1). So when I allege that my 25(1) right is alleged violated, first is, my lord, there has to be a restriction on that right. And that right, I am saying, it's my religious faith, it's my practice of faith that I have to wear a headscarf. Now, my lord, when that is alleged to be restricted, the question is, where is the law? And I say, my lord, there is no law. Education Act, my lord, according to me, is not a measure of social welfare or reform for the purposes of 25(2). There is not even one judgment, my lord. I'm sorry, my lord.
Yes.
You were saying something, my lord. Yes, my lord. So there is not even one judgment, my lord, which talks about an alien act and says that, look here, the accidental consequence of some provision in the act is used to justify a restriction of fundamental right. That has never been our jurisprudence. The restriction, my lord, which is prescribed by law has to be very clear. The intention to restrict a practice has to be very clear from the act. The intention has to be evinced not by what the AG says, my lord, not what we say, but by the act itself. Now, my lord, the act has to say that, look here, this hijab is not a practice which is conducive to XYZ reasons, and therefore we are making a law. An Education Act and some unrelated, my lords, uniform rule cannot be a measure of social reform. And I cite, my lords, one or two judgments on that count. My lords may kindly have first.
There is no need for citing any judgment on this. We accept that.
Yes, lords, why I am saying is that restriction, number one, has to have a direct relation to the object which it seeks to achieve. If the object, my lord, is to say hijab is a regressive practice and that uniformity should prevail over hijab, Lord, that has to be evident from a plain reading of the provisions of the Act and, my lords, the rules made thereunder. And I say, my lord, the Education Act or the rules don't, my lord, evince any such intention. And in fact, my lords, I wanted to cite the Constituent Assembly debates. Kindly have a look at that volume, my lord, which starts at page 447. In fact, what is being propounded today, my lord, was actually propounded, expressly rejected, and what is sought to be resurrected, that we will have a uniformity, nobody should show any religious symbols, would amount to, my lords, sitting in judgment and reversing what our framers, my lord, expressly declined to do. And this is my lord's categorical submission. Just have a look at the debate on, it starts at 447 at page 469 of
Which
the,
is tell the name of the debater. Was it K.T. Shah or Dr. Ambedkar?
Yes,
if
my
you
lord.
mention the name, I'll write down.
Yes, my lord. Kindly have a
Which
look at page
discussion,
470. My lords, an amendment was moved by Mr. Tajamul Hussain.
Yes.
Tajamul Hussain. The amendment read, kindly have a look at page 470. No person shall have any visible sign or mark or name, and no person shall wear any dress whereby his religion may be recognized. An amendment to this effect was moved, my lord, expressly negatived by the framers of the Constitution to Article 25. Now, my lords, the state, in my respectful submission, my lord, is trying to resurrect this. The court, my lords, by its orders, is trying to resurrect this, and it is not permissible, is my respectful submission.
Yes.
Then, my lords, the next submission which I want to make is on, my lord, this silo argument. That, look here, 19 is a separate right, 25 is a separate right. If you ask for 25, 19 gets excluded. And in fact, the AG, my lord, made an astonishing submission.
But I have replied to him. Quoting
Yes,
R.C. Cooper, I have replied to him. They are
I'm
not
grateful.
watertight compartments.
Yes,
Very
no.
good. Next point.
As an officer of the court, I had to, that was repelled in R.C. Cooper, reiterated in Maneka Gandhi, my lords, and lordships will also note in Puttaswamy, my lords, in paragraph 298, just have the citation, my lords, 2017, 10 SEC, page 1, para 298, Justice Chandrachud says that in fact 19 and 25 are together. So therefore, my lord, that silo argument is totally wrong.
Right.
Then, my lords, constitutional morality is cited. And my lord, there is a overarching, some kind of an overarching principle of constitutional morality. And that, my lord, will restrict the exercise of a fundamental right. I again say, my lord, that is totally inversing our rights jurisprudence. Constitutional morality, my lord, is not a restriction on fundamental right. Constitutional morality is a restriction on state's power. Every decision, my lord, of constitutional morality, whether it is Nautej, whether it is Sabrimala, are all decisions, my lord, pro-choice. Kindly make a note, my lord, they are not anti-choice. Today, what the state is saying is that use constitutional morality to defeat choice. That is not the jurisprudence. Constitutional morality, my lords, is pro-choice. Access to institutions, my lord. Access
It's
to
a restriction on
temples.
state power. It's a restriction on state power. Yes.
Yes, my lord. I'm grateful for that, my lord.
Agree.
Then, my lords, lot of arguments have been made on possibility, my lord, of abuse. That if we do this, then somebody else will do this. A Brahmin boy will turn up. Somebody will turn up with something else. I say, my lord, in constitutional adjudication, we cannot decide on hypothesis. Your lordships will have to decide on the facts. And I will only cite, my lord, that 1983, volume 1 SEC, page 147, my lord, this is Sanjeeva Coke. And just mark the paragraph numbers, my lord. Paragraph 11.
You have not given in this compilation.
No, my lord, it's not there. We judges are not authorized to make disembodied pronouncement on serious and cloudy issues of constitutional policy without the battle lines being properly, lordships are aware of this, my lord. Then, my lords, some submissions have been made, my lord, on other jurisdictions. And I have to point that out. Mr. Puvaya, my lords, made some submissions on other jurisdictions. And he cited, my lord, European court decisions, etc. Lordships may only make a note. As far as Mr. Puvaya's submissions are concerned, he's handed over a written submission. At page 20, at page, my lord, 21, he has cited, my lord, at page 14, in fact, he has cited a European court decision from Turkey. And he says, my lord, that headscarf ban was upheld. Now, kindly see, this is a decision, my lord. And subsequently, this decision, my lord, has been overruled. And that decision, my lord, my learned friend will handover, my lords, of the Turkey Constitutional Court. They have reversed that headscarf ban. My lord, that decision, my lord, my learned friend will just hand over of the Turkish Constitutional Court. My lords, one more point which I want to make. Some of the councils have said, my lord, that this is against international practice. And my lord, it was never my case that this is against international practice, etc. Because that submission was made, I have to rebut that. My lord, there is a parliamentary enactment called the Commission for Protection of Child Rights Act 2005. And if I can just hand over that compilation, that act is there, I will not read it. Shaul, if you can just hand over to the Honorable Court. That act, my lord, talks about rights of children. And the rights of children is defined by Parliament to mean, my lord, the same rights as is granted, my lord, in the Convention of the Rights of Child. And the Convention of the Rights of Child, which is, my lords, ratified by 196 countries, including India, expressly and incorporated into municipal legislation, expressly recognizes headscarves. So, my lord, let us, lords, that's what the point I'm making. Just have a look at, my lord, I'm not going to just have a look at volume 4. And just have a look at, my lord, article 4, first the section, our parliamentary act, page 47 is that act. And this I am not citing as any new point. This is only in response to say that this is a regressive practice. I am showing that this is not a regressive practice. Wearing a headscarf is only a display of diversity. Just have a look at, my lord, the act. It starts at page 47. At page 50, my lord, is the child rights definition. That is section
You were mentioning
2B.
about Turkish judgment overruling the other earlier view. What difference it makes to us? We have been following Denny, even when his judgments are reversed by the House of Lords.
Yes, my lord. No difficulty. No difficulty, my lord. Since judgments have been cited at the bar, it's my duty as an officer of the court to point out that overruled judgments have been cited.
All right.
Yes,
Thank you. So far as
yes.
recognition of hijab is concerned, nobody is denying that hijab is not a recognized headdress. Hijab is
what has been argued?
recognized headdress.
No, my lords, kindly see what has been argued is that it is a regressive practice. It has been argued, my lord, by my learned friends. It is against constitutional morality. We are living in a society which should not be, there should be uniformity. And therefore, no religious display should be shown. Why should a girl be covered with a headscarf? That arguments have been made. In response to that, I am saying,
with respect to dignity.
Yes.
That is with respect to dignity, it was argued.
That's right, my lord. That's
it
right.
was not that in any manner.
No, my lord, I just want to point that out. And my lords, the other jurisdiction which was cited was France. And lordships, I have given the convention. France and Turkey, my lord, are the exceptions to this convention on child rights. France and Turkey, my lord. Lordships may make a note, and that's there in the compilation. Then, my lord, lastly, I want to say is this: that what is the net result, my lord? The net result is today people who want headscarves, my lord, or who want a turban, Sikhs, are being denied on the pretext, my lord, of the geo. What is eventually happening, my lord, is that their right to education, which is paramount and an overarching principle, is being, my lord, put on the back burner.
Yes.
And I say, my lord, as a state, you should facilitate. You should create an enabling, my lord's atmosphere in which that right can be exercised. Because lordships will just make a note. In 2012, my lord.
Positive secularism. You mentioned that judgment.
Yes, my lord. I am on right to education. No, my lords, I am on right to education. 2012, 6 SCC, page 1. Supreme Court Chief Justice Kapadia's judgment clearly in paragraph 32, my lords.
Tell the name of the judgment. Tell the name of the judgment.
Yes, my lord. I'll just give that. 2012 6 SEs. Society for Unaided, my lords.
Under the Right to Education Act.
Yes, my lords. That's the constitutionality was challenged. Lordships will recall. Yes, my lord. In that context, they examined the right to education, and they said, my lord, that it is a part of Article 25. Just have a look at that, my lord. By judicial decisions, right to education has been read into right to life under Article 21. So a state's decision, my lord, let's say even the rule, if it is eventually leading to a situation where people, my lord, are not going to have the full benefit of the state's policy to open education, I say, my lord, it is challengeable under 21 as well. And lastly, I say, my lords, on ERP, my lords, we had cited, my lords, surahs from the Quran to say, my lord, that this is an essential religious practice. The learned AG, my lord, has said, look here, this is Quran.com, and we can't go by.
First clear your stand as to whether you want to say that it is an essential religious practice,
yes, my lord.
Or whether you want to say that in order to attract Article 25, it is not necessary to see whether it is part of essential religious practice or not.
Lords, I am going to put it on two folds. One, my lord, is that I say it is an essential religious practice. There is no doubt about it. But what I'm also saying is that there is no restriction in the first place. There is no government order. According to me, the government order which puts that restriction, my lord, is totally illegal. My lord, in the absence of a valid restriction, my lords, for the court to get into, my lords, this arena of ERP is strictly not necessary. But if your lordships were to do it, I say, my lord, it is an essential religious practice. I have cited, my lord, Quran.com, and my lords may just have Quran.com is not a translation, my lord. My learned friend is wrong on that. I have given copies of the Quran.com website. It is a compilation, my lord, of various translation of all authors, including Yusuf Ali. Just Shaul, if you can just hand over that.
Authenticity of that.
Yes, that is why I want to show, my lord.
In the country has treated it as authoritative text.
Yes, my lord. Just have a look
version of Islamic law.
Yes, my lord. Just have a look at why I wanted to point out. Just have a look at this is the exact of Quran.com, and the relevant surah is, my lord, 24. And this has all the authors, Abdul Halim, different translation, Pickett Hall, over the page, Yusuf Ali, which my learned friend relied upon, and which I have also quoted in my petition. So therefore, my lord, it is not an unauthorized translation. It is a compendium of translations of all reputed authors. And what I say, my lord, is that the verses in the Quran clearly say, I have cited that in my opening.
Where it says?
Kindly see, my lord, the first one. Just see, my lords, that item 1. Yes. And tell believing women that they should lower their glances, guard their private parts, and not display their charms beyond what to reveal. They should let their headscarves fall to cover their necklines. Now, my lord, the Arabic word is khimar, and khimar, my lord, is translated, my lord, as a
khimar is not hijab.
Yes, my lord. It's
khimar is not hijab.
Yes, my lord. Khimar is a veil. My lord, it is like a ghungat, which, my lords, people wear. Now, lordships can translate it as in English, my lord, it can be a veil. But a ghungat, my lord, falls on the head, and then it comes, my lord, on the shoulders. Yeah. My lords, the second source, and my lord, just make a note, Justice Kurian Joseph in paragraph 7 of Shaira Banu, which is the deciding judgment, clearly says that what is in the Quran has to be followed, and that is a part of Shariat. That is, my lords, paragraph 7. of Justice Kurian's judgment 2017, 9 SCC, page 1. My lords, the second source of Islamic law is the Hadith. And Hadith, my lord, is also the first source, is not a second degree. That your lordships will see Justice Nariman's judgment in paragraph 54 in Shaira Banu. Just make a note, my lord, that Hadith is as authoritative as the Quran itself. And the Hadith I have handed over to your lordships. Yeah. Come on, give it here. My lords, that is it's a collection by Shahi al-Bukhari of the Hadiths, my lord. And this is the, yes, it's mentioned in my writ petition.
Sahih Bukhari.
Yes, Sahih Bukhari. I'm sorry, sir, I'm not well conversant, so please pardon if I have.
Sahih Bukhari.
Bukhari is the name of the author.
Right.
Yes.
Yes, I'm told, my lord, Sahih is correct and Bukhari is the name of the author. But just turn to the last page of that, my lord. The Hadith stands on the same footing as the Quran, as per para 54 of Justice Nariman's judgment in Shaira Banu. And there can't be any dispute, my lord, as far as this is concerned, as far as what is the importance to be given to Hadith. Now, please see page 2, the last page here. Chapter 12, verse 24, 31 is explained.
How it was practiced.
And how it is practiced. Narrated Aisha, may Allah bestow his mercy on the early immigrant women when Allah revealed and to draw their veils all over their Juyu Bihinna, their bodies. Kindly see, my lord, their faces, necks and bosom. They tore their murut, woolen dresses or waist binding, clothes or apparels, and covered their heads. This is what I'm saying, my lord. This is the practice which is, my lord, the first degree of source for Islamic law. And there is no dispute, my lord, as far as this hadith is concerned at all. And my lord, lordships are aware, my lord, Aisha is the wife of the Prophet. And my lord, lastly, none of the councils, my lord, appearing on the other side, have disputed two judgments of the Kerala High Court, single judge, division bench, and also Madras High Court, my lord, which has gone through, my lords, these Islamic verses, scriptures, and has come to a conclusion that parda or a burqa may not be an essential practice, but a headscarf is. And my lord, my learned friends have not cited a single decision of any court in the country, my lords, saying that headscarf is not. And I have cited, my lord, a minimum of 3 decisions of Indian courts, which, my lord, categorically say that headscarf is a essential part of Islamic religion. My lord, so therefore, my lord, I respectfully submit that, yeah. My lord, therefore, I respectfully submit, my lord, that the GO, which is the basis for our action before your lordships, is totally illegal. There is no restriction, legal restriction, my lord, for exercise of Article 25(1). And I am sure, my lords, I am reminded, my lord, to end with what, my lord, Dr. Ambedkar said, my lord, when he actually finished, my lord, drafting the constitution along with the other lords, fathers of our constitution. And he made a speech, lordships are aware. He said, my lord, we may have a great constitution, but the people who implement it are bad, my lord. It will turn out to be a bad constitution. And I dare say, my lords, the way the state has implemented this, a good constitution, my lord, has been totally frustrated. But I am equally sure, my lord, that we are in the hands of a constitutional court, my lord, and we will make our constitution work. And I'm sure, my lord, that justice will prevail. I'm grateful for a very patient hearing, my lord. Lordships are sitting till 5. I am really grateful, my lord.
That seal cover process for me.
Yes, please. Yes, please.
May I, my lord,
they made 3 sets.
may I just say May I, my lord, seek your lordship indulgence, my lord?
Oh.
I am appearing in 3088.
They may be given to chief.
Yes, yes.
My lord, I am party in person. Tomorrow is Jumma. Kindly.
So it contains some material note which is in the part of progress of investigation. Right?
No, therefore we also don't want to see. Only under the chief.
But lordship can see. I have no problem. For a moment, we had in fact made 3 sets.
Give
I made 3 sets, but now that lordship say
give one copy.
Yes.
Give one copy. We will see. And we will return it to you, noting the content. Now we will continue tomorrow. Whatever the remaining counsel for petitioner want to say in rejoinder, they may make their submission. We will assemble again at 2:30. And tomorrow we will finish up with the arguments part. And we will request all of you to prepare your written submission and file, submit it to the court within 2-3 days.
Lords, I have already given one. Any additional, my lords, points which I have covered in the rejoinder, I'll give a supplemental written submission.
You have already filed the.
Yes, my lord. My rejoinder submissions also, I'll put it in a written note so that your lordships are
give it whatever you want, you give it.
Yes, yes.
I am at your lordship's beck and call anytime, my lord, your lordship can.
Give it in the time.
I'm at your lordship's beck and call.
Seal it.
My lords, tomorrow is Jumma. Kindly pass an interim relief that Jumma hijab can be allowed on Jumma Fridays. Your lordship had assured me that.
Where we have assured.
With respect of 2146.
You had told I will consider your prayer. Your lordship had categorically stated last week, my lord.
We'll continue.
Grateful. I'm highly obliged.
Submission of various name of the advocates and say that put up tomorrow at 2:30.
Please, your lordship.